$1 million in crowdfunded money, purportedly for his lawyers, and his lawyers didn't end up doing much work. So I mean, which means the rest of that went to him. So
Right,
it's a whole different world.
Which, as a tax lawyer, Mr. Barnes, that creates an interesting question, right?
Yep.
Because ostensibly funds are coming in for legal defense, and you can depending on the type of crowdfunding or the profile of the person, maybe they're all tax deductible gifts, right? Or tax exclusive gifts of under the $13,500 gift limit. That was probably a couple of years ago. Maybe they are, but then maybe not, because if you've got a high
most structures are often income, and they don't know it. They don't realize that all of a sudden they have, let's say they raised $1 million legal defense fund for an exceptional case. They don't know all of a sudden they owe $350,000 and $400,000 in tax, depending on which state they live in. It's a whole different animal.
It's an interesting thing. And I think, again, aspiring lawyers out there who want to create a very niche and special practice, you start figuring out how to manage crowdfunded legal fees, how to establish rock solid trusts or tax exempt entities that can function with this. You will make a fortune if you can get your name out there and be ahead of the curve.
Especially if you could raise money for anybody on the grounds the funds are only going to an attorney-client fund, establish relationships with payment processors and banks that are mostly immune from attack platforming, you'd have a near monopoly on the business.
Yeah, it should happen.
I'll be right back, guys.
When are we forming a partnership?
No, I'm going to go set up a business right now.
Yeah, well, and that's the trick, right? Because Rittenhouse got removed from GoFundMe because GoFundMe has specific policies that says we will not allow you to fund a criminal defense of a violent criminal act or one that involves
unless of course,
hatred or something else.
Right. Unless, of course, you do it for rioting in Minneapolis. Then
then you can do
GoFundMe's
it.
all go.
Look, but did Chrissy Teigen donate, though?
Go.
Exactly.
If Chrissy Teigen's going to donate, then you can crowdfund whatever you want at the end of the day. But
well, I know in my own little narrow space of self-defense law, we see a lot of these same issues with these self-defense insurance policies that people can get, whether it's USCCA or CCW Safe, and I don't want to get into the different companies, but people think they're buying insurance. I mean, that's why they call it self-defense insurance. They're not insured. Maybe the parent company has some kind of reinsurance thing set up, so when they pay out fees for one of their members' expenses, they're reimbursed by whatever their insurance is. But the individual member is not getting any kind of insurance. They're getting a promise from the company that they'll pay the legal expenses. And frankly, I've seen cases, self-defense cases, where the company looks at it and says, we don't like this one. We're just not going to pay.
So is there any one of them you'd particularly recommend? Because I get asked that question.
Me too.
I don't know. Should I get in? You want me to talk about it?
Yes, please.
Hell yes.
Okay. Well, in full disclosure, there's one I'm partnered with. It's CCW Safe. I'm partnered with them because I think they're the best one for a variety of reasons. One is that there's no cap on their coverage. So some of these programs, they'll say it's $1 million, $2 million in civil coverage, but it's only a couple $100,000 or $250,000 or whatever it is for criminal defense, which is, listen, if you're charged with aggravated battery, that's probably enough. If you're charged with murder, it may not be enough, right? You're charged with murdering several people, like Kyle Rittenhouse, is definitely not going to be enough, especially if it becomes a politically energized case. And then what happens if you get a hung jury, or you get a retrial, or you get an appeal? Well, once you've exhausted that cap, you're done. And let's face it, in a murder trial, you're definitely burning for $250,000. So there is no ongoing coverage. One of the reasons I like CCW Safe is they don't place any limit on it. They'll cover your trial. If there's a hung jury, they'll cover the retrial, the appeal, all the way through the end of the process until it's exhausted. And given how much money this stuff costs, I think not having the cap is enormously beneficial. Another thing I really liked about them is more personal. Their national trial counsel is Don West, who's one of the attorneys in the George Zimmerman trial. And I just think the world of him personally. So any legal defense use of force case that has Don West advising counsel, I think is a big step above where they would be otherwise. And they're no more expensive than the alternatives. Some of the alternatives I don't like because, like I said, I know of cases where members come in with a self-defense claim and they just decide, well, we don't like the way this one looks, we're not going to pay.
Name and shame. Who don't you like?
I don't want to go into that level of detail. Maybe offline. But I'll just say the one I recommend people look at most closely is CCW Safe. It's not for everybody. It's not the best fit for everybody. It is for me. I'm a member, but all people can do is go look at what they have to offer and decide whether it's a good fit for them. But at least God forbid if something happens, you don't have to worry about selling your business or selling your home or cashing out your kid's college fund to pay for the legal defense.
Right, and as we've seen, even Kyle's a great indicator of this. Even someone with a clear fact pattern that legally supports self-defense, so much so that it's in the complaint written by the state that self-defense occurred. It's in their closing arguments. You're still, if the circumstances are ripe, you will be charged, and they will run you through the ringer. Kyle had a $2 million bail. He had, who knows, any estimate on how much this legal defense has cost? I mean, just taking, 60 hours of jury trial. He's got 3 attorneys there. Granted, they're Midwest attorneys, but I have to imagine they're each $400 an hour.
Well, I can tell you the Zimmerman defense billed out at close to $2 million. Now, they didn't get that money, of course, because Zimmerman didn't have it. But
I was wondering how they came with that number. It seemed like a lot.
Well, they have that money from the bail fund, right? And so, over here, they have 2.6 million, not just the 600,000. And the lawyers know at the end of the day that $2 million will become attachable to cover their fees and expenses.
Oh,
so
Zimmerman, his lawyers didn't get paid. I mean, he didn't raise anything like that money. He raised a few $100,000, and I'm sure they got that. But the rest of it, they just didn't.
The reason he did it probably is because he didn't have so much video showing how heroic he was in his restraint of using his weapon compared to Kyle, where we all see that. I mean, the video evidence that we all saw for the last 14 months, unless you were closed-minded or Joe Scarborough, was that this kid doesn't fire unless his life is really in danger, and that's something we all can relate to.
Well, Joe Scarborough, he really nailed it. He had his hand on the pulse. He figured out exactly, 60 rounds. I'm surprised that he conservatively estimated 60 rounds, to be honest. I was...
I just think immediate confession from projection, but speaking of rampant murder, does not Joe Scarborough have something of a questionable history that this would be the way he saw the events in his own mind? Nobody knows the Joe Scarborough
Did
story.
Joe murder someone? I feel like
Did
I
he
heard
Baldwin?
that.
Did he Baldwin somebody?
He didn't. An individual was found dead in his office.
Tell us more. I never heard this story before, Vito. So this sounds
Are you
really
joking, though? Oh. So I just think...
I don't know how the
Joe
dead body got there. It's in my office. I don't know.
Everybody takes a beating sometimes, right?
Then you can look at the facts in Rittenhouse, and then through their mind guys see 60 shots, firing left, right, and center. There's some projection going on there of what they expected to see in their mind's eye, or what they actually do see in their mind's eye. Yeah, that was another bad take. There's been a bunch of bad legal takes.
He had a little Twitter war with someone here on our panel yesterday during closing arguments. I mean, the guy sitting over here to this side of me here.
It's not a war when you get nuked from orbit. I mean, that's
true. Yeah, but Joe Scarborough
He ate a little bit of a ratio.
Went after Nick Rekieta, and I actually made a veiled, not a thinly veiled reference to his lack of understanding about this case and not about the facts because he's difficult time finding a good secretary. So we were well aware of.
Well, I'll tell you one thing, Nick, you saw it, and I think other people tweeted it out before I did. But Tucker Carlson was quite clearly making reference to what happened to your stream yesterday on his show. I'm surprised he didn't go with the name on air, which would have been great, but
would have taken away from some of their streams, Viva. He can't do that.
That's true. Fox News did have a net benefit when that happened.
They got to get the rhinos there, streaming about the legal matter.
I heard there was an article in Breitbart also about it. I don't know if any of you did any hear about this.
Oh, come on, stop it. You already read it on stream, you weirdo.
Oh, that one.
Look, every journalistic outlet should definitely write an article about it so that I can use that for a blue check on Twitter, so I can become immune like all of the other Twitter people, so I can say whatever I want.
They're not going to give you a check mark, even if you wanted one.
I've applied now 3 times, and not that I care about the check mark. I wanted one when I was running for office, just so that I could make sure that nobody would put out, phony tweets. And then I tried again afterwards, because now that I've got a Wikipedia page that has like legit stuff on it, like results from the local federal election, I thought I could get it. I've been turned down twice now. But
it's almost like that's an express requirement, right? That you have a Wikipedia page that talks about you and that you are a public figure who literally ran for office.
In federal office. I tripled
weird.
the PPC vote, and repeatedly. The first time I applied, I tried the celebrity or public figure. Second time it was for the election. Third time was after the election when I had my Wikipedia page has the federal election results for Notre Dame de Grâce Westmount. So anyways, I'll try again and keep trying just so I can dilute the idiocy ratio of the blue check marks on Twitter. But Andrew Bronca, I don't know if you noticed, people in the chat were saying that the CCW Safe website crashed, and I went to try to log on, and it was certainly slow to get access.
Look,
Someone's probably wondering.
I just want to say this stream is not brought to you by CCW Safe, but it could be.
put in an affiliate link.
It'd be a $5 super chat.
Well, if all those folks who are interested would like to save 10% on their CCW Safe membership, they can use the discount code LOSD10.
I am proud of the grifting in this stream, but it makes my heart warm.
LOSD. Now, what does that stand for?
Law of self-defense. It actually can include the of, because without the O in there, it's not quite as...
LSD.
I'm gonna
Law enforcement attention.
I'm gonna undercut you if they ever sponsor me. I'm gonna demand LSD be the promo code. Legal self-defense. That's my thing. That's what I'm going with.
By the way, Viva, if you ever apply again a 4th time to get your blue check mark, because you check all those boxes, I highly recommend that you get a guy who's great at that. Get Kraus on it to represent you with them. Just like make sure, check everything you're doing there merits you that spot, because he's very good at making sure that he's going to cover all that.
Oh, that was so terrible in my opinion. Like he looked just like a
That was
bumbling
angry.
fool.
He was so angry, I thought he was going to tear his paper, honestly. Those checks were violent.
It was like an angry wife just before the divorce. Let me go through the list of all the ways I hate you. Let me tell you a few things you don't know about yourself.
I saw like a Ralph Wiggum giving a speech in high school and thinks that makes it look better. Like, okay, yep, got that one, got this one too. That's how good of a lawyer I am. I made a list and I'm checking it off for you all to see. It looked terrible, but it was not what he did. It was what he said. And those two things that he said shall live in infamy.
The checking things off was the least of his problems.
Yep. No, I was thinking.
Yeah.
Sometimes you just get a beating. I mean,
Everybody takes a beating sometimes.
Let's and yeah. God.
Let me tell you, I doubt
and they're
that the
playing
women
some music
on that jury
here.
were thinking that was playing very well for them.
Yeah, that was not my initial reflex, but when people brought that up, anybody has said that's going to rub people the wrong way, undoubtedly. But meanwhile,
I'm sorry, I never take a beating ever, never have, and I hope I never will.
and I don't show up to I don't show up to gunfights with. He says he showed up to a fist fight with a gun, and who said it? No, he showed up to a gunfight with his fists, and you don't have to prove your manhood by dropping your gun and going.
What if he wasn't trying to show up? Kyle wasn't trying to show up at any fight. He was fleeing and fleeing and fleeing and fleeing until he could flee no more.
I thought that was a very sad strategy when they actually put up a picture from the Roadhouse with Patrick Swayze there. With
and as one of our local board members mentioned, in Roadhouse, apparently Patrick Swayze takes out a guy's whole neck with his bare hand, so it probably wasn't his best movie.
Someone said there's a Binger press release. Is that a new thing? I haven't seen anything
What would
like
he
that.
possibly say?
Well, are you subbed to
He
his
has another lapel
OnlyFans?
pin
Because
that he
I
wants
think
to
that's
show
what he's
Maybe they found another drone.
I want permission to reopen to bring in Jump Kit Man. Can I reopen?
Maybe the evidence fairy stopped by again.
Yeah, I don't see anything in regards to that though. So if somebody's got a link to it or can direct me to it, I would love to.
I would say that's almost next to nil that he's done something.
Yeah, I can't imagine he would jeopardize in any way the case at this point.
I mean, if today comes back without a verdict, well, normally prosecutors don't like that. In this case, I'm sure Binger and Little Binger and sauerkraut or grill.
Yeah, they'd be happy it's not self-defense straight up.
And yet, I'm firmly of the opinion, and I had a disagreement with Nick about this earlier, where I believe that Binger and Kraus fell in love with their case. I think they invested so much time in it that they've made a classic mistake that many lawyers make, where when you sit there arguing a position, at a certain point you lose the plot as to whether you're sounding logical or not. And we saw that evidence in the rebuttal when he makes that insane argument. Well, everyone takes a beating sometime and thinks this is compelling. But if you're a lawyer who falls in love with your case, you tend to think that every argument you're making, that everyone in the world is going to agree with that, even if it's completely nonsensical. And I'm wondering I'm wondering from some of you newer people, some of you were here when I made this point before, but those of you who weren't particularly, if you can weigh in whether you think that falling in love with the case may have misled them into thinking that some of the stuff they're saying is a winner. And in which case, if they did fall in love with the case, they might be under the impression that a quick jury decision is a sign of conviction. And that's why I'm bringing it up now in this context. So I wonder what you guys think about that.
No, hold on. Joe, we got. Is this a legit press release, Nick?
Yeah. According to this person, it's a press release that says I'm not going to do a press release.
It says
no
no
press.
Exactly.
Yeah.
But that's a press release, and he's citing the reason for which he's not going to do a press release is ethics, and so he's citing a press release based on his ethics. This is knowing darn well that the jury is probably seeing what's going on in the media, and now he's just saying, I'm so ethical, I'm not going to make a press release while the jury is deliberating.
Or after. He's specifically saying after the jury reaches a verdict, he will not comment.
It's a call me maybe.
If it is
Which
unethical,
that's unusual. I mean,
Maybe
most
he's
of
preparing
the
to
time
lose.
prosecutors do a press statement after a jury verdict. To be honest with you, this suggests to me he's anticipating a bad jury verdict.
Yeah.
Because if Binger was going to get a good jury verdict, he wasn't going to, crowd for the cameras. No chance. He wants an excuse as to why he doesn't show up if it's bad.
But what ethical requirements would bind him if he comes back with a not guilty?
I'm looking
well, Wisconsin Supreme Court rules 20 sub 3.6 and 20 sub 3.8.
A lot of Wisconsin prosecutors have been violating that over the last 2 decades, if that's his interpretation is correct.
After George Zimmerman was acquitted of all charges unanimously by the jury in Florida, prosecutor Angela Corey had a press conference where she called him explicitly a murderer after his acquittal.
By that same token, if he's found guilty, the prosecutor's not going to shouldn't be able to get up and start arguing his case even more just by virtue of the fact that there's going to be appeals. I mean, ethically, wouldn't that? I mean, Andrew, isn't that?
I've never seen it stop anybody.
It's never stopped anybody before.
No, I understand, but I'm saying if we're going by the book, the prosecutor is, if you're not supposed to. Obviously, you can't prejudge a jury, and you shouldn't prejudge a jury. And judges, once you have a judge to decide something that is not a jury, obviously what you're saying in the press, those standards are minimized a little bit. But still, you have to be careful what you say for ethical reasons.
I checked the section, and it's just it's basically model rules of professional conduct 3.6 and 3.8. So
if he knew that it was unethical, or if he thought it were unethical to comment afterwards, he is now admittedly doing something that is unethical by commenting on how he's not going to comment, citing his ethics. That's a statement that he just made it knowing that he thought it was unethical.
Isn't this the same guy who made reference in front of the jury to Kyle Rittenhouse asserting his Fifth Amendment rights?
Oh, yes.
Yes. Yeah, so
Don't get brazen with me.
He committed, by his own argument, committed a crime by pointing a dangerous weapon with his finger on the trigger at the jury.
And then he asked for a photo op. Oh my goodness.
Maybe we're looking at this wrong, because the statement has to qualify, right? It says a statement referred to ordinarily is likely to have a prejudicial effect when it refers to a criminal matter that could result in deprivation of liberty, and the statement relates to like the character, credibility, reputation, or criminal record of a party. In a criminal case, it could result in deprivation of liberty, the possibility of a plea of guilty to the offense, of the resistance, performance or results of any examination or test. By the way, all of these things have been testified to at trial already, most of the time by Binger. But maybe he just won't be able to contain himself from attacking Kyle Rittenhouse relentlessly because he's got no chill on his temper, and if he knows he can't let Kraus talk to anybody, because Kraus will just he'll sound like Tasmanian devil, right?
Yeah, I mean, and the predicate to this rule is have a substantial likelihood of materially prejudicing an adjudicative proceeding. So after it's over, it's unclear how it applies.
It's never been interpreted, to my knowledge, to apply after a jury verdict. Prosecutors almost always do press conferences after a jury verdict.
He expects a hung jury, and he doesn't want to prejudice the subsequent trial.
The next one?
Right. That could be a circumstance in which he has to be careful.
Yeah,
but even then, it's you have a right of free speech. There's more restrictions on the state than the defendant, but in this precise, because I've litigated this precise issue in Wisconsin, and there's a lot of constitutional constrictions on the scope and scale of that.
Right.
My view is he's only saying this because he wants to pretext in case it comes back. He's put it this way: if he was anticipating a better chance of convictions than anything else, he doesn't put out that statement.
That's fair. I mean, I think you might be right. He's lashing himself to the mast. He's making the commitment now so that he can explain why he's not available if it was be something that he feels like he wouldn't be able to control or would be otherwise negative towards him.
Gentlemen of the panel, Nick, I'm going to duck out. I recognize that there's a jury today. I will be giving up my seat to another lawyer. But everyone, thank you. It's been nice talking to you, and see you tomorrow this evening.
Take it easy,
Sounds good. See you.
Excuse me.
Click leave studio, you Canadian. Robert, this is a question maybe you can uniquely answer. I don't know. And there's no advocacy for anything like this, but many people have asked what could be done about the perceived indiscretions of Binger, for example, in this case. I mean, I personally think he has acted unethically. I'm not opposed to him in this case. He's not, I'm not representing someone opposed to him in this case, so I don't take it upon myself to do any reporting or whatever. But is there some process? I mean, my main thought is, you could write a letter to the Kenosha County Attorney's Office and just say you're kind of disgusted by what you see. But again, I'm not advocating for stuff. I don't do stuff like that. I'm just curious if you have any thoughts on it.
So, I mean, several components. From a remedial perspective from Kyle, he can always seek a mistrial with prejudice even after a jury verdict or if there's a mistrial. Now, the problem is that's now easily appealable, whereas a mistrial with prejudice motion while there's jeopardy at issue, not always clear, even in Wisconsin, when exactly that is or is not appealable. But and then you have a risk that the appeal takes so long, by the time it comes back, maybe sure there's no effect. So that's your kind of exposure there. But there's that risk. They can always request the court seek some sort of remedy or relief, either a referral or a sanctions order or a factual determination, something like that. Then otherwise you can seek relief through the local district attorney's office, Kenosha, elected official that controls his employment. There's various DA ethical bodies that can make potential kind of inquiries. And primarily it's the Office of Law, Regulation, an administrative agency under the control of the Wisconsin Supreme Court that can actually take disciplinary action against them. And so all of that can be initiated and instigated by anybody that's simply aware of the facts that lead up to it. I think what Andrew said earlier is correct. Unless the trial court judge really comes down on him, it's going to be very difficult to get anyone else to take remedy.
I just don't see anything substantive being done to any of these prosecutors who really act in egregious ways, who they hide evidence by not hiding it, right? They bury it under so much other evidence that it's impossible to find. They swear out complaints that are never proven at court. There's never any evidence shown for critical elements of a criminal charge. Marilyn Mosby, the state's attorney in Baltimore, charged 6 police officers with crimes as serious as murder over the death of Freddie Gray, and there was never any evidence that any of those officers used unlawful force on him at all. And nothing happens. She just gets reelected. She stays. They try to sue her, and they throw it out over prosecutorial immunity. Nothing happened to Angela Corey in Florida. I never see these people being held accountable.
Well, and that's the problem with the state bars, right? And as a regulatory body, and I'm sure we can all get into that. I mean, that's, to me, number one. We were talking about crowdfunding earlier. That just brings up all the issues with just the Byzantine regulations that are selectively enforced, right? There's always the in crowd and the out crowd, who they're being enforced against, who they're not being enforced against. I mean, I've always had a huge problem with that as just a regulatory structure. And I think that's reinforced here. The fact you need to reach such a high burden in order to have anything happen, other than perhaps maybe a written reprimand. I think that's, to most people, that's not right.
Well, I think in a realistic world, you would hope that the folks with that kind of power would have the lowest bar, that they have the highest obligation. And if you're not up to it, then, hey, all right, go make your business elsewhere. But we need people that are effectively above reproach. And that's clearly not what is happening now.
Just to kind of, this is a little bit off topic, but I guess Jack Posobiec just like 4 or 5 minutes ago tweeted that 2 jurors are holding the decision up, outright citing backlash for U.S. Marshal in Kenosha.
That's what I was just about to say. So thank you. Yeah.
First of all, how's a U.S. Marshal get involved in this?
I don't know.
If there, I mean, there could be just a U.S. Marshal who happens to be in the courtroom, not in any official capacity.
Why?
Only if there's federal security applicable to the jury, which would be unusual. Normally this would be bailiffs. The only people who, and usually the bailiffs are not in the actual jury. That doesn't prevent them from overhearing things. And it depends on your state court. I had a federal court judge who the jury came back, told the bailiff they had a question. He was panicked that it was going to lead to acquittal, and he didn't want acquittal. So he did an ex parte instruction to the jury outside the presence of counsel, out everybody. Total violation. The judge was known as Maximum Moody. Just because he as it turns out, he panicked. Going back to a point Andrew made earlier, I actually picked a juror who was very open about his biases against my client potentially, because he was so self-aware and so self-reflective. I was like, wow, I can work with him. He ended up being the foreman. The jury deliberations went longer than the trial. That's what panicked the judge. And it ended up being a very fair jury process. But yeah, so a judge who wants to know things can know things. They're not supposed to, but that doesn't, it's only the judge who has real control over what's happened in that jury room. Bailiffs, same deal. They want to listen in a little more, they can, and then the word can spread.
Right. It's a Ferris Bueller deal, right? It's my sister's cousin's aunt heard that Ferris Bueller was whatever, blah 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 blah, and it's impossible to know the veracity of it.
It's most likely informed speculation, but it's probably what it is. I know of at least I heard from, not from the defense team, but from other journalists, that they thought there were at least 2 of the 12 that looked bad for Kyle. 2 Karens, as they put it.
I will say that in my experience, Jack has been remarkably accurate in these kinds of things.
Yeah. The one interesting thing is apparently the thin walls theory that was voiced by another name a little bit ago. There's actually a clip of the judge that someone DM'd me, and you can hear the clerk, even though she's way off mic, say they can hear you in the library while he's snapping at Binger. And the idea, that's where the jury goes, right? They move out into the library if they're only out for a temporary time. So it is certainly possible that there would be somebody in the courthouse somewhere that might overhear something, either coming from a jury room or them talking to the judge about something. We don't know.
Well, the other, you could always have a juror talking to.
It's also like Legal Bites. The reason I haven't brought it up and played the clip over and over is because I think I played it on one of my nighttime shows. It's really hard to hear. And I worry that what I'm hearing is being influenced by what I read that someone says is happening. So I don't know. I can't verify it, but it does sound a lot like that happened. Now, that's probably not that big of a deal because he's yelling at Binger. It's not prejudicing the defendant. If they hear that, it prejudices the state, and I'm sorry, but I don't care. You can prejudice the state all day, and I will never ever shed a tear in my entire life. But yeah, interesting update from Mr. Posobiec, and it would be, who knows? It's plausible. There are demonstrators outside the courthouse today. Something that has not happened, but not very many.
The only other possibilities mentioned in the chat, there have been threats against the judge, and sometimes, even though U.S. Marshals only guard federal judges, they do sometimes help protect security of state court judges.
There you go.
Because it's a federal civil rights violation for someone to hurt a state judge under certain circumstances.
Well, and we have an across state lines threat, right? The nephew of
Cross
the
nations,
foreign
across
country of
worlds.
Antioch, like the foreign country of Racine.
Oh, you guys are
was a good one.
taking a joke. I was being serious. The guy who threatened the jurors is George Floyd's nephew, who I presume to be in Minnesota. That's
Right.
he's
I
done
see
that.
what you mean, yes.
He's
There
doing
could be a
done that
federal
using-
investigation lingering.
Right. That's done using interstate communication over the internet. Therefore, I mean, you
So
could,
normally that would be FBI, people like that. Marshals are only usually security or federal courthouse.
right. But I'm just saying, since they have an interstate threat, they may employ federal defense in this specific instance. I don't know the process. I'm just speculating. But
Right.
Come on, Robert. The FBI is too busy turning out late footage. You know, they gotta dig deep through their files.
Oh,
We got our
yes.
drones. We got our drones.
When is
Yeah,
Jump
so-
Kick Man going to give a speech outside the Kenosha courthouse? That's all I want to know right now.
Well, the question is, of the 30 people protesting outside the Kenosha courthouse, what percentage of them are feds? And I think that's reasonable. I think that's a reasonable question.
Again,
at
where we're
this point.
sitting.
Non-zero, I would say.
Harvester of Sorrow says, at this point, I honestly believe the best Kyle can hope for is a mistrial. If that happens, how likely would it be that Kyle gets a new attorney?
One can only
Hopefully
pray.
high. I mean, I'll put that bluntly.
Literally
So,
anyone. Anyone else
I
would
was
be fine.
patient before trial, but not anymore.
Well, I think
If it's a
when you go to
mistrial, it will be a mistrial because they screwed up, and enough's enough. And he needs to get better counsel. And David Hancock, the security guy who's hijacked the family, basically, functionally, needs to be out. And he needs to have a real legal team and a real media team and a real investigation team, not this nitwit, half-wit with spooky connections running the show and hijacking the funds.
Now, I do have a question. We talked about this in regards to Fifth Amendment privilege, but let's say and I think I know the answer, but mistrial occurs, they're relitigating. State tries to bring in some of this evidence that definitely should have been objected to this entire time. Do they lose the ability to have those objections because it's already been in the record, or you can still object
Totally,
to that? And then
totally new from scratch. Not only that,
Okay.
I mean, Kyle doesn't have to be called to testify. It gets complicated whether they can use his testimony from the prior proceedings in a mistrial situation. But you get to renew every evidentiary objection, whatever happened. The only thing, what is the state cannot bring back a curfew because that was dismissed after jeopardy, and cannot bring back the gun charge because that was
Right.
dismissed after jeopardy. That's the only thing that can't come back. Anything else can come back.
Yeah, and that's good news because that is the predicate for their case. I mean, if that's why I'm so annoyed that the judge waited so long when I feel that the complaint is deficient, since the complaint doesn't allege that it's a short barrel rifle. So I think it fails pleading standards on probable cause. But why that was such a problem is because they used that as a predicate for the prosecution and then had to attempt to work around it as the prosecution progressed. And so it's like, if you don't have this, you don't have a case because you don't have provocation. But of course, now they will, going forward, attempt to bring that FBI or that drone footage in the second time if they get another bite at it. But
I mean, a mistrial and a retrial would be terrible, but at least in the second trial, presumably the defense team would actually have the image gutted, and they'd have a use of force expert actually providing some use of force testimony. I mean, the judge limited what Dr. John Black could talk about, but he didn't limit it as far as the defense limited themselves. I mean, the judge just said, listen, I'm not going to let this guy proclaim to the jury that this was lawful self-defense. And that's right. He shouldn't be permitted to do that. But he could have talked about things like how fast someone travels when they're charging at someone, the dangers of wrestling over a gun. Those are all components that all Black did was say these shots were 0.76 seconds apart. I mean, you didn't need him for that. You could have just brought in some audio file to do that.
And
Or if you're the prosecution, just brought on a regular detective and just asked him the question on direct.
you used a stopwatch, right?
And
Let me ask y'all a question.
that was a case where Binger just baited Richards. He was like, "Oh, if he dismisses this, I won't call my nitwit." because his expert couldn't even testify in direct because they didn't timely disclose him. He would have solely been a rebuttal expert, number one. Number two, he was not good. It was clear he was not good.
Terrible.
Who
No,
cares?
he was-
You shouldn't be intimidated by him. And Black was good, and they just blew it because Binger said, if you only limit it to these little second thing, then I'll withdraw. And he should have said, heck no, I want him on this and this and this and this and this.
You want Black on there for his one line during pretrial, right? I could figure out how to kill a man with a skateboard. Yes, you want that guy on there. He's hilarious.
Things that are outside, because that's actually outside the ordinary knowledge of an ordinary jury. Well, how
Agreed.
dangerous a skateboard is and the ways in which it can kill people. That is not commonly popularly known.
And of course, the prosecution played it up, right? Oh, we should let Santa Claus know and all the parents know who buy their children skateboards. How dangerous can a skateboard be to the head?
Very
Fatal.
Well,
yeah.
I know I, as a kid, would have preferred an AR-15 to a skateboard, so I hope that's what Santa does bring. More kids in Wisconsin.
I wonder how many people have been killed by baseball bats. I mean, let's
or
just get
hockey
real
sticks
with it.
if you're Canadian.
Yeah.
Yeah.
I mean,
Oh, that's
Canadian.
many hundreds of murders every year in America with blunt instruments, hundreds with bare hands and boots.
That was a point someone on the panel raised the other day, is that there are more feet and fists murders in the U.S. annually than there are rifle murders in the U.S.
This is true.
annually.
Yep. This is very true.
So just nonsense. If he does, I don't want the kid to have to go through anymore, right? I want an acquittal, or if they get a mistrial, for them to just go ahead and dismiss it because they're losing the bulk of their initial provocation claim. But if he does go back, I really hope that he gets somebody on that defense team who will stand up and just object, who won't concede on their expert and limit their expert outside. Like, his sort of expertise was video, but they even limited the behavioral and perception aspects of video review that he was that's his PhD, is here is what someone in a video perceives in real time and how they take in that information. It's like, that's what you need. You don't need someone to tell us what's on screen. We can have any detective do that, apparently. Or we can have, hell, the DNA forensic expert, because for some reason the state didn't object when they're like, yeah, so you're looking at this, he's grabbing the gun, right? And the state should have said, she wasn't there. But anyway, you have this guy who can actually do this as an expert, and then they just forfeited it because the threat of Bob coming in a greasy t-shirt with potato chips is going to outdo John Black. It was silly.
Running this without a use of force expert it's unfathomable to me, because you do need to explain things. How dangerous is it that an unarmed guy is running at you? Well, the prosecution was making huge noise about that. I guarantee you, I've made this point before. There's no police officer on the planet that wouldn't have dropped two into him right there. Every officer who's saying, I've got my gun, he's charging me, he's reaching for my gun. It's so frustrating to watch.
I thought it would have been helpful to have medical evidence without the necessity of trial testimony. Because someone would say, someone who's been hit in the way he has, how would that impact his perception of consciousness? How would that impact? I mean, if basically you got a guy that's, doesn't know what's happening, his head has been jarred and has been hammered with a head on a rock, then pushed to the ground, then hit on the head with feet, then hit on the head with a skateboard, you're going to be in a discharged state of mind, and all of a sudden you see any threat coming, you're going to defend yourself.
That's a really good point. That was never brought up.
The best part about John Black is he could have likely, credibly testified that he has both had that happen to him and done that to someone else. Like, the way his CV read, it's like, okay, this guy's been a cop for 23 years. He was in the armed services for 30, and he's been how old is this man? And how many people does he have buried under his basement? He seemed like the guy you would have do all of this stuff. And
well, I don't know if you've talked about it before, but have we talked about whether there's any chance, if it's hung in certain respects, that they still get to a verdict on others? Like, if I'm looking at it, on the ground guy with a gun is, to me, the most obvious.
Sorry, they cut from the courtroom feed on one of them to the outside feed, and so there's an idiot with a bullhorn yelling.
Yeah.
Well,
no, all I was saying was
is a bad idea. It's just what the justice looks like, I guess.
Prosecute the police. Sorry, but you were.
I was saying was, I do think I can imagine a composition of the jury that says, okay, guy with a gun, sure, hitting the head on the ground, sure. I'm not as convinced because this small little person that can't threaten this guy, and he should have fought him because everybody takes a beating sometimes. And could you get into a scenario where it's only the first count that becomes trouble, and that it's not worth it to try him again on only a little bit of the case? Or is it such a political case that if there's going to be holdouts, they're going to hold out down the whole road?
I mean, any acquittals are good for Kyle. Those are not things that can be retried, and it limits the scope of retry.
Yeah, and that's what I'm asking is it's so hard for me to envision having a lot of difficulties with this particular case because there's so much evidence and it's so odd. That things are really usually a lot more ambiguous than this. And if they're having trouble with anything, I guess my concern would be you just hold out down the whole road. That just doesn't apply at all.
Yeah, and that's what we were finding.
All right.
In pre-trial polling, they were hardcore holdouts.
And that's what I'm curious about. Yeah.
And that's why jury selection had to be done differently than it was done here by the defense.
There's a very large donation that I want to address from Black Flame Nova, and it's an interesting question. It says, all right, this is a one-time donation. How can media be allowed to use the freedom of the press to mess with trials, make the jury afraid, etc., but our Second Amendment shall not be infringed means nothing? Where's the justice in law? Where's the accountability? Great stream. Much love to you all.
Another secret we've been
Does anyone want to address the disparity?
The Supreme Court would be nice if they showed up a little bit more frequently in the Second Amendment. They do have a case this term, finally. New York State Pistol and Rifle Association versus Bruin, on the extent to which carry outside the home can occur without arbitrary conditions, such as please prove to us that you have an exceptional need, which definitionally excludes the ordinary person. So is that kind of a rule valid?
And that was an interesting argument. You should check it out.
It was a good argument. In fact, I covered it on my channel. I have a 3-hour stream on my channel breaking down that entire oral argument. You should check it out.
We'll check that out. Yeah, absolutely.
And
3 hours. Oh man,
uncivil.
That's
It was the Cliffs Notes. Come on.
Yeah, uncivil. What I heard from people was the oral argument sounded like it was going to be a favorable ruling. Is that your take or no?
That does seem to be the direction where things are going. The New York State Solicitor General was not very good, but everyone else was good.
There's an expression
and
in
of course the lead was fantastic because no one is that good except for
my
them.
house is your house,
To the point of question wise, like every term the Supreme Court takes up a couple First Amendment cases. They've taken up a couple First Amendment cases every year, time immemorial, for the last 50 years or something. So when you're deciding like 3 cases every year, you get 150 cases. That's a lot of case law. For reasons that we can only speculate about, the Supreme Court hasn't taken up anything of note in the Second Amendment for 12 years. They keep punting on everything, even though there's a lot of great cases. So one of the reasons our Second Amendment rights are not as well flushed out as our First Amendment rights is because the Supreme Court doesn't want to. So how about that for an answer?
And prior to that, it was, what, 60, 70 years almost?
Well, yeah, if you want to go all the way back to Miller, which as Barnes has noted before and I've noted before, is one hell of an interesting decision, particularly because Miller's lawyer didn't show up. Miller himself had died. Miller's lawyer apparently stopped getting paid, so Miller didn't show up to the U.S. Supreme Court, which apparently is an option. So it was just the U.S. government arguing U.S. versus Miller in 1923. And that was the last time they took it up, and before that was probably Crushank in 1860-something. So it's not been great for the Second Amendment. It's been a little bit unloved. It needs a little bit more love.
Well, Nate and I also, we did a breakdown of that Second Amendment case, the oral arguments there, and I concur with uncivil law that the direction that the justices seem to be taking, specifically the 6 conservative justices, actually sounded pretty conservative, even Kavanaugh and Barrett. In fact, Kavanaugh, surprisingly so, sounded, the form of their questions seemed to be leading towards a direction. And New York, the attorney for New York State Rifle and Pistol Association was a gentleman named Caldwell, who was phenomenal in the way that he argued. He was I thought he was really, really strong. And the questions were basically, okay, so what standard do you think we should apply? When he came forward with a standard that, they were examining, should we look at strict scrutiny? Should we look at intermediate scrutiny? And and he was, and whatever standard he was applying, Kavanaugh was like, I don't think that's good enough. I don't think that judges will misinterpret it and be too harsh in allowing some of these statutes that shouldn't stand up. If you're going to embrace that statute, we'd have to go even further than the Petitioners' Council is looking for here. So it was very encouraging.
It wasn't. It was Clement who argued for.
Did I say? I said Caldwell. Yeah, you're correct.
Yeah, Paul Clement,
we should do 12 hours on how make no law resulted in levels of scrutiny at some point.
It's ridiculous.
Well, we could get into a whole analysis. Do we want to get into a long discussion about this? Because I fancy myself a bit of a knowledgeable person on this topic.
Well, one thing I just want to say though is that to the question, to the super chat though, there is a huge balance if you look at the volume of what can potentially be violated of speech versus Second Amendment rights. So when you see an imbalance, there's just so many more things where speech is triggered rather than Second Amendment, which explains a lot of that volume.
On that question, I want to just follow up with a thought that question inspired me to have, which is you could see potentially a conflict in between First Amendment freedom of assembly and freedom of speech with trying to protect the jury from a mob that's calling for a verdict to go the way that their emotions are carrying them. And I wonder how the panel here would feel, even though in our current political climate it seems inconceivable that any legislature would pass such a thing. I guess some conservative states, right? And the question I'm getting at here is, let's assume that a state like Florida will pass a law that you can't assemble within, let's say, half a mile of a courthouse that is deciding something significant like that, because of the threat of there being a mob that will intimidate the jury into a decision that is not in keeping with what their actual findings are. Whether you guys think that such a thing would stand scrutiny from the court.
Well, no. I mean, especially the kind of distances you're talking about is way too far, even for some sort of time, place, manner restriction. But I think that more fundamentally, the jury system has always been a community-based decision. There's always been members of the community coming together to judge things, which is better than the judges doing it, because we saw how well that worked out. So I'm not necessarily sure it's completely antithetical to the idea of the jury system, that members of the community are expressing their opinions, particularly on issues of the day.
I can't disagree with you more on that. I can't even believe that those words came out of your mouth. You have a mob outside that, especially given the current climate right here and now, this minute, what we just heard in the background there, we have a mob out there which clearly we can imagine that many of them never bother watching 10 minutes of this trial.
The First Amendment doesn't require people to be well informed.
I understand, but you're saying it's a communal decision about the defendant, and much of the community here doesn't know anything about the facts of the case. They haven't been watching anything, so it's a community which has been reduced down to 12 people. So those 12 people shouldn't be influenced by other members of the community who have absolutely no idea what the evidence should lead any person to conclude.
I was saying it was logical for people of the community to want to have an opinion on what things go on in their community, and they should be able to express those views, and those views do not have to be well informed. So I'm a pretty strong First Amendment guy. I'm not quite an absolutist, but I'm pretty strong on the First Amendment. And I think you should have the right to express, your views, no matter how stupid they are, pretty much anywhere, and that should be even up to, the courthouse steps, barring safety concerns and making sure people can get in and out.
How does that not lead to jury taking, though? How does that not lead to pushing a jury and swaying them to ignore what they've heard throughout the trial and reaching decisions based on mob mentality as to what the people outside the doorhouse 10 feet away from them are going to be screaming at them, hurling at them, and potentially putting their lives in jeopardy 3 minutes after they reach
you're having to pick one, basically. You're like, okay, your concern is reasonable. People outside the courthouse are shouting. Let's assume we're in sort of 12 Angry Men territory and the windows are overlooking the alley or whatever, so they can literally hear those screams coming up. So you have one of two decisions. You can either say, all right, the jury is so important that we need to back these people further and further up so they can't be heard, or the First Amendment's more important. But, I think the First Amendment's more important because I think it's the First Amendment. I think freedom of speech is the paramount freedom. And the right to say things, no matter how stupid you are, is paramount. So that's
gentlemen,
right to a fair trial.
Gentlemen, on point with this. So this is in the theme. I'm in the theme here.
I'm loving the argument, though, that the First Amendment is facing facing whether or not it impacts the jury trial.
So Sobiek has tweeted out in response to his own tweets, right? He created a thread while we weren't looking. He has more worried about the media leaking their names, what will happen to their families, jobs, etc., including doxing threats from, quote, anarchist groups. This is according to, again, Posobiec's alleged source. So it's qualified within that, but with that
Sounds like they
information,
want to quit.
that sounds like an
Sounds like
acquittal.
they want to quit, which is the right decision.
It does.
By any means.
So why should they be held up even 30 seconds by the thought that their lives will be hampered?
Well, but how do you avoid that?
What I'm saying,
How do you,
at the very least,
it's like the old
at the very
question,
least, they shouldn't hear the shouts of a mob screaming outside their windows while they're trying to make a decision.
I mean, how would you prevent them from hearing about it in this day and age, short of setting up like some sequestered bunker?
I understand what you're saying.
Well, and the other aspect too here is that they're not just worried about the people that are right there on the street. They're worried about the people that are coming for them at their job. Worrying about the people that are coming after their families. That's not something that you can really impact just by moving a crowd back 200 feet.
well, as we were, I don't know,
Rittenhouse can
ironically,
protect
made
them.
point earlier, but normally the highest tier of speech is the political speech. It's as high as it goes. It's the most protected tier. So people are having an opinion about not even what the law is or maybe what it should be, because there's outrage maybe that the law sucks. And maybe he should be guilty in some more abstract sense because the law is in a profession to deal with this evil, which is a reasonable position, no matter how much I disagree.
Wait. What, Robert, what were you about to say? You were going to say something.
I mean, yes, this is also an excuse by bad jurors in a persuasion argument. So if it's the case, the way bad jurors were arguing in Rittenhouse's case, and I've seen it in other cases, is to persuade they say, I don't want, we just can't issue that kind of verdict. The community will get really mad. That's not okay. Sometimes it's completely legitimate and sincere. They don't want to be part of that. But usually it's because they don't want to be part of it for political reasons, not just because of their concerns of blowback. But often it's a persuasion argument. They believe it's a persuasive argument to the other side. We got to do some sort of verdict here, otherwise the community will go crazy. That's not particularly on the left. This has been a common refrain in general.
Yeah.
See, I think this is at the key of the tension between Joe and you on civil is because it's selective enforcement. I agree with the law as on civil arguing. I think absolutely freedom of speech is first and foremost. But I think what's behind a lot of what Joe's getting pissed off about, what I get pissed off about, is it's selectively enforced, right? The left is allowed to do this, while if the right came out and did a similar thing, they would arrest them all, round them up, and send in the FBI, right?
Well, I've always tried to be as consistent as I can on my channel on applying principles universally. When there's a reason I've got 54 or whatever videos on the Capitol riot series, because I don't care if they're right. If people say, well, it's really Antifa, it's really BLM. I was like, I could give a damn either way. I don't care if it's Trump supporters, Republicans, whatever. As far as I'm concerned, the vast majority of them have done illegal things. They need to be prosecuted. That seems to be the result. Because I also think, for example, when they're burning the cities of Kenosha, that's equally bad, or more bad, depending on the scale of crimes. But either way, it should all be prosecuted. It's all bad. So I say, well, freedom of speech for the left, freedom of speech for the right. It's all good.
Yeah, legal mindset. To respond to your point too, though, I mean, if the argument is that they're not enforcing it on both sides, the answer is not to not enforce it on the right. You know what I mean? Like it shouldn't be not enforced on both sides. It should be enforced on both sides. So.
And I'm not saying, look, uncivil is not the enforcer of these laws. He's just stating the law as it is, right? But
I'm also stating that I think it's fundamentally a good thing. So I'm also stating a normative argument.
And I'll tell you this much. I don't understand how that's an infringement of time, manner, and place to the point that we're gonna. I mean, Elite is making a point here. Sorry, Legal Bites is making a point here that.
Same. I
understand, but you don't. People might not recognize your name, so that's why I went back to your stage. So, I think the point you're making is saying that they feel a threat to their jobs or whatever that's going to happen days or weeks after the trial. That actually makes my argument all the stronger, because whatever concerns they have about that level, if you allow a mob to come up to the doors of the courthouses, as uncivil law is advocating for, all the more that will make them that much more concerned that this is a real threat that they're going to be dealing with for a lengthy time. You're actually letting that ring in their ears as they're trying to reach a decision. I just don't understand how we are hurting our basic First Amendment rights by limiting time, manner, and place, which we do all the time in many situations.
There are
The
less
court, by the
remedies.
way, if the court believes they are within earshot of the jury, you can move them out of earshot.
Yeah, I mean that's fair enough.
That they've established that's an exception, First Amendment wise, that there's you can limit free speech to the degree it impacts directly on the jury.
I think the big issue here, though, is ultimately which is more important to the extent of its intention: the First Amendment rights of the protesters or the right of the defendant to fair trial, which is also enshrined in the Constitution.
Well, my other issue is are there less extreme measures? For example, I've taken no particular position on the jury members themselves being professionally anonymous. So that would be another remedy that I might support because, well, I'm not sure why we particularly have to write their names. Any member of the public who is in there might know who they are, but there's no reason to broadcast that or keep a record or be FOIA-able. So that might be a remedy that's easier. I'm very reluctant to infringe those First Amendment rights.
The concern is that the other First Amendment right is perceived that public access to the court is protected under the First Amendment, and part of that is right to know who made a decision in a public trial, including juries. And you get the Roger Stone question, that what happens when suppression of juror names or juror anonymity allows a biased juror to get on the jury because crowdsourced information would have disclosed the bias.
Well, you should definitely disclose it to the lawyers who should be doing their damn job.
Oh, I understand that, but my own sense, my thought process is, I also think it's a good way to get rid of bad jurors. That any juror, I think that courts should automatically dismiss any juror who says they fear the public consequences of their association with the verdict. Because I don't think that's a juror who can provide an impartial verdict just by the nature of their thought process.
Necessarily disqualifies them.
Yes.
I mean, there's
Okay, that might be right.
And
That
you
was
have-
part of I argued that question for this jury.
And I'm pretty sure
they
the
decided
jury
not to
asked
ask.
roughly that question at some point in the voir dire. I listened to a lot of it.
What they did is they asked questions. There were jurors who volunteered. They really didn't want to sit on the jury. But they decided not to get into any detail on any of these subject matters. And you get the rhetorical question, which is useless. Can you put aside your prejudice and bias? The people who say yes to that are the most biased jurors because they're unaware of their own bias or their lying.
Well, and the interesting part of this, of course, is there are 6 alternate jurors, right? Like, there's nothing obligating the two
judge
people.
can't know what's going on inside that jury room. That's illegal for them to disclose. So the only way an alternate could replace that for the question in the chat is if those two decided they're sick and can't come back. That's it.
That's actually
Well, maybe. I mean, if one of the foremen or something were after them out because of their fundamental external fear, then maybe you could do it that way. But
that raises different. Normally, the juror cannot disclose what's going on inside the room. They can say we're internally deadlocked, but can't disclose. There's pure confidentiality on the internal discussions until the end of trial. Then they can, but have a privilege not to discuss.
Even if they're now making a determination outside of the merits of the case, there's no escape hatch for that.
Precise thing. That's exactly what happened in Trump's case. 3 jurors got on the jury and admitted to the other jurors they lied to get onto the jury. They had prejudged them all along. 9 wanted complete acquittal. They held out and did a compromise verdict on 3 misdemeanor convictions. On those misdemeanors, Snipes got an unusual sentence, so a juror came forward and said, "Here's what happened," and the judge said, "No, that's inadmissible as a matter of law." I understand.
Well, I've seen jury verdicts overturned because they brought in a Ouija board, so you know that.
So well, we want to call to the board, Mr. Joseph Rosenbaum. Mr. Rosenbaum, are you with us?
And then it says ASL.
I'm loving this conversation because I find that absolutely that you can't say, okay, these people are not thinking about the case, not thinking about it one way or the other, and that needs to be corrected.
The theory is that absolute confidentiality is necessary for completely independent, free decision making, kind of like executive privilege, the kind of privilege that's attached that says we want the decision making process to have the confidence of the same thing you would have talking to a priest or a shrink. That's the theory. There's definitely limitations and problems with it, as you know.
To do this
Okay, this is a chat that follows right up on this. Guerrilla1, by the way, thank you for the very large chat. Says, gentlemen and lady, how do we fix our broken system of law and make it into a system of justice? This case has destroyed any faith I once had.
Oh, see, I hate that.
Well,
that's because of
court of
Robert
public
and
opinion.
Andrew dead pilling everyone earlier.
Yeah, I agree with you. You really got to get public opinion. You really got to push for reform, and it's got to come from both sides. Let's be really partisan. We've got to say, hey, look, the way prosecutors are acting, it's damaging to all political parties. So let's go and get this shit fixed.
And that's what I would say. You heard me say it before, but it's that high bar. I mean, so much discretion, so much power. We should be looking at it almost in reverse.
And I want to say this about criminal cases specifically, and I've said it before, and not everybody likes this opinion, but if you think that the misconduct that you're seeing in this case is special and unique to this case, you are incorrect. And we, the right and the left, have divided over this issue because the right wants to be super pro law and order, which is great, but that law and order has to also apply to the enforcement arm of the government. And so when you see what's happening to Kyle Rittenhouse, this stuff happens every single day to people in inner cities who are charged with drug crimes. I mean, it just does. And hell, I had again, in my small town, I had 3 people charged with possession of CBD oil that you can go buy anywhere in the world because the prosecutor thought there might be, at some level, THC in the CBD oil. It might be impure, and they based it off of a police officer's common understanding that these chemicals could contain THC. No testing, testing was done. They used a meth test on the CBD oil to test for THC. They got it wrong because they're very, very good at their jobs. And they wrote the report stating this. They actually wrote the report like 9 months after the testing, but that's okay. They do this all the time. And the reality is that many defendants are simply too poor to have a lawyer take the time and look at it, because a public defender has 50 to 90 cases on their docket in a small volume court. So
and look at a U.S. federal criminal case. I've represented people with significant resources. Pales in comparison to federal criminal resources. I mean, they have full access, just procedurally, full access to a federal grand jury, full access to federal law enforcement officers, full access to federal investigative databases. They can coerce and compel anybody, any place, anywhere, anytime to produce evidence. You have almost nothing as a defense lawyer other than the right against self-incrimination.
Yeah.
And you get to mute, Andrew.
And you get to pay for your right against self-incrimination as well. You get to pay to assert that in court. You have to have a lawyer, or you don't have to, but you get to have a lawyer do it.
You know,
well,
Nick,
I was just saying essentially the
Andrew.
state has infinite resources to bring to bear for all practical purposes. And I think the right might find itself less enamored of prosecutors as we get more George Soros funded prosecutors around the country who are wrecking chaos. You know, back in the day, your local prosecutor was some established member of the legal community. Hardly anyone ran for the job. Maybe they spent a couple grand to run for that office. And he got the job because people knew who he was. He'd been around a long time. We weren't living in, and you could give that guy unbelievable discretion because he didn't abuse it. But now we have these prosecutors come in with 50 grand, 100 grand, $500,000 in funding. Their opponent has $5,000 in the bank. Who's going to win that campaign? This person's an outsider, not a member of the community. The moment they get in, they fire everybody who's already in that office and hire their friends and family to be prosecutors there. And they enact whatever social policies they want. And all the privilege that the old school prosecutor had now is theirs. And they abuse it and abuse it and abuse it. And structurally, there's no practical check on their authority. It's
Look at Kenosha. Look at Kenosha. It makes your point. We have your detective and your mayor, and I think one of the DAs all have the same last name. Like, and it's unusual, like Antonarian or something like that.
Family ties. Binger has family ties to other key political officials, and
like
he has some other ties too. But we won't.
Yeah, there you go.
I don't know. I don't know if Pasoviak is watching the stream. If you are, how's it going, buddy? He just tweeted out 1 minute ago how U.S. Marshals came to Kenosha from
I saw that
from
I was wondering if
urbanmilwaukee.com.
Wow,
maybe you heard us like wondering that.
Jack, let us know who you think is right, me or Uncivil. Please, like, weigh in on that.
What's more important, freedom of speech or the right to a jury?
Hey, Nick.
That's funny.
Yeah.
Just a quick thought, real quick. One thing is we were talking about the big picture about how, the right seems to be very, very, very big on, prosecutions and police and that kind of stuff. And I had an internet debate or actually I wasn't a debate, but somebody posted on the internet saying people who are convicted of crimes or charged with crimes should not have their constitutional rights taken away from them. And I pointed out and I said, so what about the January 6th protesters? And when I said that, they realized, oh, you're right. I mean, the fact is, it's the shoe is on the other foot. If the person that is being prosecuted or the person who is having their constitutional rights placed into jeopardy happens to be someone that you may align with politically, then you're going to be a little bit more sensitive to that nature. Hey, Nick, I appreciate you having me on the show today. My time is up. I'm going to have to get on out of here so I can get ready finish working on a brief that I'm working on.
I do legal work. Oh, sure. Whatever.
Snobby lawyers.
So you guys know, Jack Posobiec also just tweeted again. Said Judge Schroeder.
Joe is right. Joe is right.
Says
That's what he said.
He said Judge Schroeder's. He says that he's going to poll the jurors now to determine if deliberations will continue tonight.
And no, there is nothing on the feeds. I have 3 different feeds pulled up. None of them have anything from inside the courtroom right now.
Ready to go.
Well, anyway, have a good night, folks.
Thank you, Matt. Good later, buddy. Good
All right,
luck
bye-bye.
and Godspeed on your case.
Thank you, Nick. That means a lot.
He had to bust out of here because he was stuck between me and Kurt. That was probably an awkward position for
Hey,
him.
I gotta say, I don't know how many places on the internet are having advanced discussions of due process versus First Amendment freedom of speech.
No, it's
I was
always
just
a great
sitting here
discussion. I love
enjoying
it every time.
Yeah.
And that's the problem. That's the conversations we need to have. And when I talk about the right and left coming together, I saw the chat saying that's never going to happen. You're blue pilled. I'm like, yes, I'm telling you the solution. I'm not telling you that it's likely to happen. That's the whole problem.
Well,
especially when, like you said, you've
As
got
always,
people who
Joe and I
funding
are
us
having
for
a
us.
wonderful, productive discussion. He's making good points and making me
That-
think. Hopefully, the
and
same in return.
That's
Yeah.
the dream, right? I mean, that's my motto. Reasonable minds can differ. Let's have the discussion.
Or maybe
that's
reasonable minds can come to consensus because that happens sometimes too.
That's
And
how
that
we're sometimes.
And that we're doing it in
Start
front
with
of
differ. We got
we're
to
doing
baby
it-
steps.
that we're doing it in front of 67,000 people that we've suckered here with the promise of a verdict is even better.
Hey,
We trick you with education.
A hard sell there, which was what I think this is going to be pretty boring. So if you got 67,000 people with that description in the video, I think you're doing something all right.
That's true. That's true. Real quick, MAGA says thank you all. And then thank you, MAGA. And Evil Bunny says money for today and tomorrow in advance. STD retainer of, or standard retainer of, not STD retainer. That's a little different. Standard retainer of 50 per day plus Bunny. Hey, thank you, Evil Bunny, for that. I really appreciate that. Yeah, because depending on what happens here, I guess we'll find out if the jury is going to come back tomorrow, if they're going to work through the night. I would love to know.
My understanding is that someone seems to have already known that they're staying till 5:30 or 6 and no verdict tonight. That's at least that's the rumor. I don't know if that was somebody they already made that decision. The judge just hasn't announced it or what exactly. But that's what I heard.
It's not
if they're
those
not-
times yet. How do they know there's no verdict?
If there's not going to have a
If
verdict,
there's
why
not
keep
gonna
them
be one,
past
if
5?
they are not able to give one tonight.
You go in there and you work until 6, but not give a verdict. That seems weird to me.
Just keep
I think
going
they're
until we
saying
get the verdict.
Or
Yeah, yeah.
that
Do
they
it
went
old
out at
school.
5:30 or 6 and that they don't believe they'll have a verdict tonight, I think is what. Because if they thought they'd have a verdict, they would stay another half an hour, I think.
Sure.
I seem to vaguely
if they say
remember
we're ready to be out of the set
reading
time,
U.S.
know
history
no
that the founding of the country that juries were not allowed to leave and were provided like food and water and anything. They weren't allowed to leave at all until
Well,
they came to a verdict.
Trials used to be out and open, not inside a courtroom of any kind. It was out in the public. The whole community got together.
Well, see, that goes more to. I'm not sure whose point that more validates, mine or Joe's, because it's like
I
how
mean,
much
from a
more
historical
community influence
originalist
can you be?
perspective, it's Uncivil's point would be consistent with that.
Yay!
The whole community's watching and participating.
So 9 to 6 is what, 9 hours? With a lunch?
Yeah.
Yep. 9 hours of the lunch. That's how long.
That's
I'll have
kinda
been
long,
streaming
yeah.
by then.
But I don't know about. I mean, Andrew may have seen this. I've had cases where the judge holds them from like 8 a.m. to 8 p.m., 8 a.m. to 9 p.m. Tries to squeeze them into.
That's a brutal one.
Get it
There's
done.
some jurisdictions you cannot do that in, though.
That's good.
Just sequester them in a drippy dungeon and say, "Hurry up!" Like, just
Well, people should watch the Cocaine Cowboys version 3.
Love it.
It was getting them sequestered that allegedly allowed the criminal defendants to force the jury into acquittals, because there were several women who had to take care of older family members' health issues who were not able to because they were sequestered. So the defense suckered the prosecution to do the sequestering in order to influence those jurors to switch to acquittals.
I wonder if
Purportedly.
they'd still be deliberating if the defense had told them yesterday in closing that if you go with self-defense, you'll be home by dinner.
Yeah, it's a very good question, because if they're thinking that they need to approach through all of these charges individually and independently, then they might, a juror who wants to do their diligence, and even if it's just one or two in the room, who will sit there and go, no, I want to go through and think through each of these things, whereas they could have been instructed. Look, if you find self-defense in this first one,
It's over.
you're done.
Go home.
Yeah, and they absolutely can argue that at their closing. That would not be a problem for them to suggest.
Well, I mean, they made an error, right? I mean, at the end of the original defense closing, he says, "What? This is a difficult decision." It's like,
I mean, historically, a 10 to 2, the twofold. It just may not be that way in this case, because I mean that's what we're finding. 1 would hold out. Normally, the logic is if you go in 6-6, that could be a mistrial. 8, you need 8 on your side, and they can usually persuade the other 4. The leaders really matter a lot. It's very rare for 1, 2, or even 3 to hold out. But
peer
this
pressure is
case was
strong.
different because the intensity of emotion was so strong. And in my view, that's who the prosecutor was arguing to. I thought they were trying to create a mistrial by, screw it, we're not going to try to persuade the marginal person. We're just going to inflame the emotions of our people.
Challenge accepted. Get me on a jury. I will hold out against all odds. I don't even care what way it goes. Scamdemic Survivor says, what an all-star panel. Free law course worth more than any Harvard Law lecture. Thanks to everyone for making this happen. Hey, thank you. And Will Jones says, leftism must be resisted on all fronts. So that's very dramatic. Very dramatic chat.
Is tomorrow an anniversary of Election Day?
No, we're past that. That would have been
Okay.
because
November
it's the
3rd?
17th tomorrow.
Oh, yeah, you're right. We're way past that.
Yes. So, I hope not. I hope it's not an anniversary of Election Day. But no, that would it'll be interesting to see what happens. Again, I'm just confused. If the judge is going to pull the jurors and they say we don't have a verdict and we don't think we're going to be there in an hour, why send them back in the room for an hour?
I agree.
I don't get it. But Ryan Cloudier says, I don't normally do this, but you mentioned an aggregating company working to pull data, especially online, info together quickly. If you find a company that does this, I'd be very interested in applying. Thanks. I
have several of those, but not a lot of them are that accessible. We had several of them available for Kyle's jury selection, and it was rejected. But Richard Barris has a lot of that database.
I think
But
this guy
had two
wants a
other
job.
companies- Sorry.
I think this guy wants a job. That's what he's saying. He wants a job.
Yeah, well, I mean, those companies
Barnes.
exist. Just look around. You can now. Some of them have, let's say they do some interesting work for interesting folks, so they might not be that accessible in the regular world. One of them was established by X this or that. So so some of that's more available. But you look it up, you can find those companies. They're more. There's plenty out there.
Call up Dr. John Black. I guarantee you he knows them. That guy, don't you want to sit and listen to stories from him? Gotta be fascinating. He's just like, well,
Oh yeah.
you know, I once killed a man by pulling his skull apart by reaching my fingers into his eyeballs. And frankly, it was an interesting experience for me. A little squishy. DVM421 says, I hate to throw this prosecution any bone at all, but what do you think about the pressure on them to not let the city burn after what would be the obvious outcome?
Well, the city had burned.
Yeah.
Can't burn again.
And they've spent the entire trial saying that the city burning just really wasn't that big of a deal anyway. I mean, that's been their argument, is that why would you even think you should possibly put out a fire?
Just a little bit of a baby fire, that's all.
Yeah.
Just a little bit of arson.
The dismissal of Rosenbaum, right?
Well,
Yeah,
and
size
also,
matters when it
Put some
comes to
fires.
fires and guns.
well, and also that you shouldn't put out a fire because it might anger some tiny, angry little man, and then you would have to take a beating. That's how the world works.
The fire node.
Andrew, in your life experience, have you ever had a fire start big?
No, I've sure seen them get big.
Yeah, they always seem to start small, but Binger was saying these are just small fires. It was very weird. By the way, everybody on the panel who has appeared on the panel today, this is to the chat. This is for you, the lovable chat. Everybody's links are in the description. For most of the guests, you can hover over their names. It'll take you right to their YouTube pages. Mr. Branca has lawofselfdefense.com listed as his contact information. Make sure you go and check out everybody on this panel. Subscribe to their stuff. Read what they put out. Watch some videos and get some interesting education that you literally cannot find this stuff anywhere else. And it's for free. Well, sort of, for most of us. So check it out. You can get some. Again, you won't find it in law schools necessarily unless you take really cool electives, and you're certainly not going to get it in mainstream public education or undergrad.
If I could just follow up on that for a second, and that is, everyone here should realize that A, Nick is awesome, and what you see here is what you get in all the time. B, all the people who come onto this panel, the reason we're coming here is twofold. Well, threefold. One, we like Nick and hanging out with him. Two, we enjoy each other's company and sharing different legal philosophical things. But the third thing really is we are looking for the exposure here. So it's really the addition to the ability to get the exposure and help build our own channels and our own voices is part of the reasons that we donate hours at a time. If you can consider that with respect to signing up to my peers here, each and every one of them puts out high quality content, and they all call me the funny one of this group of people. So
I think you said that.
They backstage. That's what they all.
I said you were the fiery but mostly peaceful one.
Oh, okay. Fiery.
They all
I like it.
himself.
It's pronouns. Stop. Okay, so I'm just saying, if you can consider that and make sure that you guys sign up to each of these fine people here, and welcome to our newest edition here, which is Law of Self-Defense, who is just obviously
that's been wonderful.
Clearly, he's clearly brilliant.
Yeah, it's been great having you.
I definitely want to have you over on my channel. So you can
Not brilliant
so you can
enough,
make me smarter.
apparently. I just got an email from Reuters asking me if I can compare and contrast U.S. self-defense law with European self-defense law, and the answer is no. I have no idea what the European covering 50 states and the properties
You're a
of the
lawyer. You
United
can't
States
answer that
government.
question. I love
Oh
media
my God.
inquiries. What?
It's enough.
If
Talk
you want
to
to
us
chat
about
about
50
Canadian
states.
self-defense law sometime, I'd love to pick your brain.
I
but,
would be happy to do that, but I independently have zero knowledge of what self-defense law in Canada might be.
Right.
Well,
anyway,
you're required to hit people with hockey sticks. You can actually have a gun. This is a common misconception. You can have a gun in Canada, but first you have to resort to a hockey stick. And
But
that's,
only if the beaver is only over 3 inches.
and you can never shoot them from inside the crease. Like, that doesn't work. You can't do that.
Jokes are terrible.
I know. So is Canada. Okay.
Oh my goodness.
Blackguard 4 says the jury has already decided on Rittenhouse. They're just Googling the crimes of the state to decide their verdict on them. In the case of Wisconsin versus Rittenhouse, we, the jury, find the state guilty of gross misconduct. One can dream, but I think that might be optimistic.
I mean, the notion that Binger is going to face meaningful consequences, I think, is a fantasy. It's a nice one. I like the idea. but it's
No,
not.
but
gonna
I think it's to point out that under the law, under the books, under the ethical rules, he falls squarely within what should be punished, within behavior that should be punished, and like Hoke said, it's something that idealistically the bar should be the lowest. We really should be looking for people that are beyond reproach, that are absolutely people who you can look up to enforce the rule of law, so we can all believe in it. But what this is doing is it's blackpilling people, even that had previously believed in the rule of law, that have believed in prosecution. Those old Republicans that were like, "Oh, we're law and order." I don't think there's so much law and order anymore after
The
seeing
old
these
liberals,
prosecutors.
to be honest.
Yeah.
I mean, it cuts to everybody, and so yeah. By the way, you can call me Hogue. That's totally fine.
Yeah.
That's no big worry. But yeah, I'm a true believer, right? And I don't think it's a political kind of position. I want to believe in these systems. I want to improve them. And I don't blame anybody who watches all of this, watches the interaction with the institutions and how it's being reported and all of that, and loses faith. And I think the more that happens, you lose real importance in the functioning of society. And so I would very much like to see the reforms that somebody asked about in your chats. But yeah, politicization is always kind of a hot button issue. I don't think it even needs to be political, but for the way social media works and how Twitter works and everything else. We should want prosecutors held to a high standard, whether it's Kyle Rittenhouse or whether it's somebody that you like and you think is getting railroaded, because they are. It should be of importance to everyone, because the state wants to cage human beings, and that should be a very high standard that they have to hit.
Yeah, justice. The reason justice is blind is because it needs to be blind both ways, right? Like, it's Rittenhouse today. It's somebody else tomorrow. In fact, most days it's not a Rittenhouse. That's what I was trying to get at before. Yes. Most days it's someone you would have no worries about them ending up in jail. And frankly, Andrew said it earlier. If you're a criminal defense attorney, most of your clients are guilty. But the question a lot of times in criminal defense is not whether or not your client's guilty. It's whether or not their rights were respected. And if the guilty's rights are not respected, then the prosecution and the investigators are not doing the job to make sure the innocence is protected. And that is what we all need to be concerned about. Yeah, I know it might be no big deal if a judge ignores things and a crack dealer goes to jail because they ignored the probable cause statement was deficient. But when they do that, they're going to ignore the probable cause statement is deficient on someone like Kyle Rittenhouse. And
if justice is denied for anybody, it's denied for everybody.
Yeah.
I mean, one of the most common questions, any of us who do criminal defense, we've had family members or friends ask us, how can you defend those criminals? How can you do that? They're horrible. And I couldn't care less if my client's guilty or not. I mean, I care in terms of what kind of arguments I may be able to make or not, but not philosophically. My concern is holding the state to its burden, period, before they can put a human being in a cage for years or decades or the rest of their life. They have to meet that burden. That's my job. That's my concern, independent of who the particular client might be.
I had a whole debate with Ian about this late last night on our show, and we had a great dialogue about this, where I think we each walked out with more respect for the other than beforehand, even though we never came to terms on it. And I could get into a lengthy discourse in what I call the Dershowitz position, which is what you just espoused, Andrew, and that is, the concept of freeing, of freeing 99 guilty men so that we don't wrongfully imprison one innocent man. And I don't know if we go down this discussion, it's going to be like a half hour long in debating. I'm happy to do it, or I'll do it with you tomorrow when you come to the stream.
Before you delve into a weirdo debate about legal issues on a law show, let me welcome to the stream Miss Emily Baker. How's it going?
Emily Baker.
It's good. It's been a busy day. Hopefully the mic's not coming in hot. It's just been a busy day, but you guys have been having great discussions over here, and I'm glad I get to come in and pop in and say hi. Did the jury send out any notes today? I haven't seen.
They asked
SOS. The first 6 pages of jury instructions, and then they requested the rest.
They didn't just send them the jury instructions back.
They gave them 1 copy. They requested 11 additional copies.
Yeah, they want to take notes and argue with each other then.
Yeah.
Apparently there are 2 holdouts, supposedly.
Yeah, there's some extra.
How would that information be coming out?
Jack
that's
Posobiec
kind of
tweeted it.
Jack Posobiec so quotes a source as being a marshal who's there.
Yes.
And he's the one who quoted out, who tweeted out.
So
to
no idea if it's actually accurate or
Yeah,
what.
all we're going off of is the tweet on its face, and there are people who trust Jack, and there are people who don't trust Jack, and they can make determinations on the veracity of it. Right now, we're just waiting with court streams that have no indication of what's going on. Although, there were indications that the judge would be polling the jury at 5 o'clock to see what would happen, and we got nothing on the streams. I'm watching 3 different court feeds, and they have not.
The judge might have just sent a note back and asked them what they wanted to do, and then had the bailiff send it back to them saying they wanted to work till a certain amount of time, and not brought them into open court for that, because you don't really need the lawyers for that. You send the bailiff back and go, do you want to go at 5? Do you want to go at 6? Do you want to go at 7? Let us know.
Right.
So,
And the reporting on it is that at 6 they're going to go, but there's no expectation of a verdict today.
I would imagine not. It's going to take them a while to fill out verdict forms, and even if they do fill out verdict forms, they might want to come back and do it. But interesting that they requested a copy for everybody on the jury instructions, which means they're really trying to parse what they're doing, or they're trying to argue with somebody who disagrees with them. That's interesting.
And we've heard the rumor that there's 2 holdouts that are concerned that they're basically going to be ripped apart by the public.
Yeah.
Well, if that's the concern, then that leans towards acquittal. But I'm sure you guys already talked about that.
Right.
The worst jury intimidation I ever witnessed was not in a criminal case, but in a civil case with the Church of Scientology, which probably doesn't. Huge issues.
Interesting.
With that, when I was working for civil judges before I became a DA, it was wild stuff. I mean, this happens even if you don't see it in media cases. This can happen in small scale cases in courthouses all over the place where jurors feel intimidated. I had a jury send a note back once saying, we'd like to come out with a verdict, but we want to know if we can be escorted out of the courthouse down the back immediately after the verdict and not through the public spaces. So we knew kind of what they were coming back, but they were scared of the defendant's family. I mean, this is something that happens.
It actually happens all the time, all the time. But it's not usually a mob threat we're talking about. It's the other people in the community that they're worried about. They're testifying against some drug dealer's brother or something. They're going to go back there. These are people who kill people in their community.
Yeah.
So they're scared to death of rendering a verdict and going back.
Unfortunately, it's not unique. This is just on a larger scale, because I think with social media, there's the threat not of the community, but of the social media of it all, right? And they're going to figure out who my mom is, my kids are, where my kids go to school, and be harassed from people outside the community.
And then not be able to get away from it for maybe ever.
Right.
Just be completely destroyed for the rest of your life. That's a concern that people have, and that's not
You'll
unreasonable.
never know, right? Your kid won't get into a college, and you'll never know.
Yeah.
And sometimes
Right?
those people are police officers too. I've had people who've had to leave their town because they've, ticked off the local police. And it happens to jurors as well, I think.
You don't want to get pulled over every time you leave your house for some, I saw you swerve a little bit. Let's take a look. Let's smell your breath. Let's see what's going on.
There's always probable cause if you're in a car.
Yep.
Yeah.
Facts.
I think a judge has actually said that specifically. Not My Regret says, hey, look, this is how I see it. You shouldn't allow people to protest right outside a courthouse for the very same reason. You can't push for a certain candidate near a voting place. That's a position. I don't know. I think we have a lot of case law that suggests that that the courthouse is one of the most highly protected places of public speech. The fuck the draft case, a guy wore a leather jacket that said fuck the draft into the courthouse. He was sanctioned for that. And they're like, no, I mean, if anywhere gets protected political speech, and I can't imagine going into a courthouse with profanity on my clothing. This guy did it, and they tried to punish him for it, and he ended up winning that. So it's there.
Yeah, but
You've seen it though, right?
That's not.
I've seen people
That's not going to
all kinds
create
of stuff on.
that.
Oh yeah.
The F the draft T-shirt or jacket, whatever he's wearing there, is not something which one can foresee will lead to imminent bodily harm. I think so. I don't see how that's really comparable to the situation where the whole where the mob outside the door could foreseeably lead towards imminent bodily harm.
And I'm not saying they're comparable in that way. I'm just saying that this.
And yet you're bringing it up. You're bringing it up.
Look, I'm doing the lawyer thing. I'm doing the lawyer thing. No, it's just a place that has traditionally, by the Supreme Court, been overtly protected and set aside as this is like you may not have freedom of speech anywhere else, but how can we deny it from a courtroom, right?
It's the
like
political arena. It's
Yeah.
where it lives.
That's
It's-
dicta. That's dicta.
I'll give you something.
It's
that
been a while
involves
since
dicta.
somebody's yelled at dicta at me.
Yeah, when it comes to dicta, balls are no balls. So there you go.
Tall Skinny Geek says, I hear Full Metal Jacket 5.56 rounds and an AR-15 are really good for self-defense if any of the jurors need safety. Yeah, just
give them each an AR-15.
Give them each their own Rittenhouse. That'll protect them from all threats, foreign and domestic. I think. Let's see.
I'm sure there's a gun shop out there that would sponsor them with an AR-15.
Cindy Mack says, thanks for the insight and the jokes. Nice job making the law entertaining and relatable. Oh, thank you. That's to the panel, I would assume, because I, haven't done anything good. I'm just sitting here citing case law, and Joe's over, dicta.
Because that element, as far as saying that that's protected, that requires protection, that's dicta as far as just,
You're going to sit here and argue, you're going to credibly argue that the Supreme Court saying that the courthouse itself is the political arena and needs the highest order of protection for political speech is dicta?
I'll review. Give me your citation. I'll review your case.
I don't remember the case.
He wants a brief filed, Nick.
Okay, yeah.
Ask the chat for a brief. Ask the chat to brief it.
You could just Google "fuck the draft case in Supreme Court" and you'll get it. There you go. Brian Lips says, blame Canada from South Park. Sing it out, Nikki. I'm not singing. No. I've been streaming for almost... Yeah, it's been almost 9 hours. I'm not singing shit.
You guys have been chatting for 9 hours.
Well, 8 hours and 45 minutes.
Not all of us.
Nick has been chatting for 8 hours and 45 minutes.
Yeah, Emily, I'm going to subpoena you for an entire stream one day and just ruin your entire day. And just
it would kill me. It would just absolutely no. It would not. I love the conversation of being able to, and people don't understand lawyers, and maybe watching the stream helps. That disagreeing can be fun. Disagreeing should happen. You can have conversations. You can explore different ideas, and that's part of how everyone A, understands better, but B, becomes stronger in their own position, or maybe sees another position. And that's part of the back and forth of lawyers, where most people are like, oh, you disagree with me? I don't want to talk to you.
Right.
And that's
how
a
we grow.
very big difference. And there's not a lot of space in the internet where you can actually have reasonable disagreements and chat about it and actually not have hard feelings about it. And I think you guys getting to do that and go back and forth. I saw a little bit of Joe and Uncivil chatting about where you can protest, where you can't, and they're valid conversations that need to happen. So I love it.
I just got an interesting thing that said someone purporting to be Mark Randazza has joined the channel. Thank you for that. I don't know if it's actually Mark Randazza, but I'm going to pretend it is from now on. Either way. So thank you for doing that. Very much appreciated. Emily,
been watching Bankruptcy Court earlier this afternoon, which is what I was doing.
Why?
By the way, your case is Cohen versus California, which I'm reading now while you go through Super Chats.
Why Bankruptcy Court? Erica Girardi.
Oh,
No,
yeah. That case is wild.
So I'm getting DM'd all over the place here. As apparently the Activision workers have walked out.
Oh, fantastic!
Yeah, I did a video on the article, and now I'm getting a bunch of requests to cover it again, maybe tomorrow.
Good.
But they apparently are walking out and asking for Bobby's resignation.
Briefly summarize the Activision case. As I understand it,
can you?
The whole case? Well, I mean,
elevator pitch it.
No touching.
Yeah. What happened today? Activision's in trouble for sexual harassment and assault and those kinds of things. And what happened today is the Wall Street Journal put out what I would call something of a bombshell type article. In which they essentially
hey.
In Arizona, it forms a metropolitan area with Phoenix and Glen.
Hold on. What the hell? Let me go back a little bit and pull this up. Sorry, I didn't mean to cut you off.
One guy in the chat is saying that the judge is back, the judge and jury are back. There's a guy in the chat saying that.
There's a lot of guys in the chat saying that. I haven't been able to trust him. I backed it up
just
a little
one.
bit.
How
PBS
about
is
meteorology and these discharges associated with
The quartering in the chat is saying the judge is back as well.
Oh wow, okay, so that's him. I trust.
Cumulonimbus. British authors for 600.
he's
Are
playing
they
jury
playing Jeopardy with the jury?
Jeopardy with the jury again.
He wrote The War in the Air as well as The War of the Worlds.
H.G. Wells, right?
Correct.
I'm sorry, what is happening?
The judge plays Jeopardy with the jury to kill time. The feed is really, really bad from the court today. It's been doing this loading thing.
War in the Air as well as The War of the Worlds.
Wow.
The
It's
next
like a
question is:
dreamscape of just hearing judge phrases.
he was acquitted of all charges in Wisconsin versus Rittenhouse. The answer is Rittenhouse.
My God, I don't know whether people would have more respect or less for the legal process.
H.G.
Just
Wells,
given
very
verdicts
good.
by-
All right, how about after
I had a
marrying
judge
an
that used
American,
to
he
like to
moved to
tell
the
lawyers
U.S.
that
where he
when he
wrote
was
2
killing
Jungle
time.
Books.
The jury.
Who is Rupert
said
Kipling?
Very good.
Somebody's going to accuse him of racism for this too.
I want to
having
clip
the-
out
the
that
most
very
fun.
good.
Yeah, is this just a
Well,
hot
my
What's
mic?
happening? Why?
My feed
what
has gone
world
back
are
to
we
the
living
portrait
in?
now.
Yeah, I see
Yeah.
a long time back on the
About
portrait.
warbirds during
Back
the
to the seal.
Korean War, the U.S. unsheathed the F-86 named for this after a cavalry sword.
Saber.
What is the saber? Yeah.
I feel. Okay.
Why are they waiting for the lawyers to come back
Like-
in?
I can't
Hey,
figure
Hey
out.
mom, I went to law school and now I'm playing Jeopardy on
Very few people
YouTube.
are.
They've got money on this.
This right away. During the Korean War, the U.S.
This
unsheathed
is how they're settling the verdict.
You already read this one, Judge. Come on, get on there.
named this after a cavalry sword.
I don't know if it's repeating. I don't know what's going on. Again, here's
Twitter
PBS's
says
feed.
Judge Schroeder just came out and said, "Y'all think something's about to happen, don't you?" Clerk says it's not. Seems we're doing Jeopardy.
Is the judge seriously just trolling us?
Oh, I bet. I wonder if he's playing Jeopardy with the alternates.
All right, now what is this?
To bring
Has
the
he been doing
alternates
this
into
for
the jury
9
conference.
hours?
See a bunch of alternates hanging from nooses in the courthouse.
Yeah, I was gonna say.
They're like, could you send Rittenhouse in here and I'll rush him? We'll just
Yeah,
see how this goes.
please, please.
It was
Oh.
Jeopardy or story time with
Four-letter
the judge.
U.S. cities. The most
Oh, this
I guess
feed
the
is
process-
so terrible. Does anybody have a feed that's actually playing?
Yeah, mine is
Playing
fine.
for
Law,
me, but
law
I'm
and
not
crime
trying to
looks
scream
like
at the
it's-
same
well,
time.
This is long crime, and I am just like I am getting a ton of lag on it. I don't know if it's my own fault.
I've got
Which
the
is
same
possible.
feed and it's not spinning for me.
Same.
But I have it on a different computer.
most populated city in Central Oregon. It's a mecca for outdoor enthusiasts. Who said Ben? About 4 people. Okay.
Oh, I think I fixed it.
What is mate? Come on.
Come on.
I know what I gave the answer already. They probably still won't get it.
The
right.
question is, how should we settle this case? Trial by
There's only
combat.
8 forms of metro.
Did he just diss
Oh.
on the jury?
He just
Metropolitan
hated us.
area with Phoenix and Glendale. Mesa. Who answered that? Yeah, and you're from Chicago, so you know Mesa.
He hated heavily on the jury
did you ever
there.
go to-
I
did
gave
you
him
ever
the
go out
answer.
there to
They'll
spring
still
training?
get it wrong.
Did you ever go to Don and Charlie's restaurant? Oh, it's
What is happening?
fun now anyway. They had a lot
Anyone
of.
ever been to Don and Charlie's?
Could be.
Oh my gosh.
The judge keeps his job for the social opportunities.
It's remarkable. It's remarkable.
If anybody has a stable version of the stream, because I'm having issues, and you want to share it, I'll share your screen happily, if you can do that. But I'm having clearly having issues getting the downstream.
Memorabilia there. How about advertising and marketing for 600? It's the two-word alliterative term for the prominent display of commercial goods in films or TV shows.
Product placement.
Dang it!
We need buzzers.
He clearly he likes Jeopardy the way he said that. For 600.
Well, also his ringtone is Double Jeopardy.
No,
Right.
his ringtone always proud to be American.
That was his text message
Wait, so-
tone.
That was it. That was it.
This
That makes
man
sense.
is getting sicker by the day. If anybody didn't notice.
How about
He is-
advertising and placement for
Listen
one?
how he sounds. Oh, awful.
Well, he was definitely suppressing coughs yesterday.
Yeah,
people
he's
are telling
coughed
me to-
quite a bit over the course of the trial. I was concerned for a while that he might, you know, we might end up with a different judge.
1,000
People are telling me to
watery
close
term
and
for
reopen the
appointed
browser. I think I will. Just a second.
Yeah, I'm wondering if they're going to send him for a death plague test.
Tell
Yeah.
you what, you never know what you're gonna get on this stream or in this trial.
The-
Ultimate
No,
juror
it's
Very
Jeopardy.
fair. I would have never guessed a prosecutor would have had their gun on a trigger pointing an AR at a jury. And
That was a heck of a photo, wasn't it?
Yeah.
All
I'm
the
saddened
memes.
that he apparently can't be charged for that, but Wisconsin law seems to make it forbidden, but prosecutorial...
Immunity?
Yeah, that's what I'm told.
prosecutorial
Okay.
immunity is a pretty darn strong thing. So is judicial immunity.
So I
Yeah,
have
it's still
the,
like... Yeah.
I'm still getting circles every couple seconds on here. I don't know what it is with me, but the hatred is real. So again, if someone else wants to share their screen of the feed, I'll happily include it. But it sounds like the judge's hot mic is done.
Yeah. So Election Wizard tweeted out a minute ago that I guess the Rittenhouse judge tells the media, I think the jury is going to retire for the evening.
Okay.
I mean, it'd be nice to actually see that.
Yeah.
Yes, other than Jeopardy, it would be nice to see that.
That's
But I don't see that on the stream I've got pulled up either, and I don't hear anything on that stream either.
Yeah, I've got nothing happening in the background. And it's up with audio, by the way. So if there was something happening, we would. Oh wait, no, I've got the. Yeah, I've even got the screen pulled up. So if there was any audio, when the circle stops, you'd hear it. But wow.
I share a screen with you if that helps you.
Law and Crime has 38,000 votes on their poll. We have a much better poll. We have 165,000 votes. So I think we win. Thanks, Joe. Oh, you pulled up the PBS stream?
It's
Can you
working.
It's nothing's there. Of course it's working.
What do you want me? What do you want me to? Which
Law
one?
and Crime. Do Law and Crime.
Give me a second.
Yeah, I got you.
You just said
My
any
law and
stream.
crime feed is working just fine. But I don't know how to share it. It's on a different computer.
Yeah, I got it.
Mine's at 360p even. It's just embarrassing how the connection. I don't know. I've not been having this much trouble lately. But today, apparently, I am. Maybe my kids are eating my internet, which is very possible.
That does happen to me.
What are they streaming?
Literally everything. That's their entire lives is streaming something. Whether they're streaming YouTube or they're streaming Minecraft or whatever. That's what they do during the day.
In my
when they're
house,
done
they
with their
have
school
tablets and TVs and phones just laying around unused, just streaming stuff all the time.
Yes.
Are
My
you
kids
using?
sleep to this lo-fi hip hop beats thing, and I'm
Oh,
like,
we have that on all the time.
yeah, I'm walking around at night. I'm like, what the hell is that sound? I'll go and they're under a blanket. There'll be a freaking tablet streaming it.
Are you?
They have good
streaming-
taste, though.
Are you streaming mine? Do you need me to keep it open here or?
No,
Okay.
keep yours open, please. Yeah, I've got yours
Okay,
on.
Okay, fine.
I think
'cause mine-
Comcast pays my kids to burn through my internet bandwidth.
It was the most surprising thing about moving from Los Angeles to Middle Tennessee is how much better the internet is here. I was shocked. It's incredibly good.
Where are you in Tennessee?
Outside of Franklin.
Ah, nice. Nice, nice country.
In Sumner County or a different county?
Williamson.
Okay. The reason why I asked, my brother-in-law is a judge in Sumner.
Oh, very nice.
you're like-
I love it out here. Go ahead.
So you're like between Nashville and Knoxville?
She's in the nice
No,
suburban
I'm
part.
pretty close. I'm in a suburb of Nashville.
Yeah.
Oh, okay.
yeah.
Have you ever
My
been to the
cousin lives there.
Peg Leg Porker?
No,
You
Well-
got to go. You got to go to the Peg Leg Porker. They have great barbecue.
we will make it
And-
happen.
There's a bunch of good barbecue in Tennessee.
Yeah.
They have,
here's
but they have
another-
their own bourbon that they make there in house, and they
That's
filter the bourbon through the charcoal left over from their barbecue. It's great.
That sounds.
Here's another
incredible.
Twitter update. So apparently, just a few minutes ago, Michael Tarm from AP Legal Affairs, he said that Rittenhouse, his attorneys and prosecutors just walked in, and then they walked back to the
Oh,
judge's
camera's
chambers, shut
moving in the
door.
courtroom.
Rittenhouse stays at the defense table, so they're having some kind of
There he is.
conversation.
Judge
There
is
he
in the
is.
courtroom.
Conversation.
Yep.
All right.
Okay, let's see. Do you have your audio shared, Joe? I hope.
You gotta
Can you
click the
hear
link to
anything?
share.
Yeah, give me a second.
Oh, Jesus.
The sound just came on.
Give me a second. Give me a
I
second.
have to rely on the help here. This is awful.
Oh, good lord.
It's coming.
Nick's pretty demanding.
Look, I'm just cranky because my
There,
feed
there,
is
go,
still
go.
behind.
Not yet.
All right, I can hear it.
It sounds
Okay,
like there's
perfect.
a question.
All right. By the way, while we're waiting for the jury to come down, the media, somebody asked from the media, and I have no idea who, inquired about the method of selection of those to be struck from the jury this afternoon, this morning.
Yeah,
whatever,
Kyle
this
did it.
morning.
It was weird.
That's been the practice in this court for, I'm going to say, 20 years at least.
What?
That I've been doing that. That the defendant in a criminal case is the one who makes the selections from the tumbler as to jurors to be
Weird.
dismissed.
They choose their own fate.
Yeah.
That's
Very
what he
strange.
did. Yeah.
It's like pick your
World's
weapon.
worst game show.
It's awful.
Yeah.
I've never seen that.
Select alternates for 600.
Just it was very odd, and I think without an explanation, when the pictures start circulating on social, it seems very odd because there's no explanation from the judge that that's their practice, and then
is
you
there
just get
any-
people's supposition.
Is there any reason to bring in the DA and Kyle unless there's a decision to make?
If there's a
Means it-
question,
Oh, yeah, they have to be there for every jury proceeding by law.
Yeah, they're gonna, even if they're gonna adjourn for the day,
Right.
right? Like they have to have them there.
Although those smiles might mean that this is a verdict.
No, there's not.
It's mute. It's
They
not
got
me.
police.
Finger's
Yeah,
looking
they're-
pretty antsy.
Look at that
Long
sheriff.
time is muted right now.
Sheriff is
Did
bracing
anyone
that
find
gal.
out what his bling is today? What's Binger's piece of flair today?
did the judge mute the mic? Yep.
Yeah.
He's probably talking to the clerk.
God, look at the Binger clone in the black jacket there behind Sharafi.
Oh yeah, with the
Yep.
laptop.
Yeah. God, weird. Your Honor, they're wreaking havoc outside of the courtroom, Your Honor. We'd like to move to dismiss.
You're in the first class seats now.
Everyone's very jovial.
All right.
It is a very happy.
I understand that you wish to break for the evening, which is certainly your prerogative. You're in charge at this particular point. And I also understand that I was told that I'm not clear on whether you decided you wanted to come back at 9 or if that was conveyed to you that that's what we wanted. But I'm going to take a vote just to make sure. How many want to report at 9?
Just to make sure.
Okay, that makes it easy. And so we're going to break for the evening.
Look, that unanimous vote.
Now you're in deliberation, and the rules are the same as they were before, with the additional provision that you can't talk with anybody about the case, even if all 12 of you by happenstance end up at the same place, a bowling alley or a restaurant or something. You're not allowed to talk about the case, even with all 12. And when you get here in the morning, if you come a little early or somebody's late, and there are 11 of you or 10 of you or whatever, you can't talk about the case. The only way you can talk about the case, any aspect of the case, is when all 12 of you are together in the jury room. So please keep that in mind. Don't read, watch, or listen to any account of the trial. No talking with anybody who's not involved in the trial. Any question, anybody? All right, thank you very much, and have a wonderful evening.
Welcome to day 2.
Yep, there you go. That's gonna be. I think that's gonna be it, pretty much, for the show today. I will be back tomorrow, and if anybody in the chat, or of course, any panelists are welcome to come back and have deliberative law discussions
I gotta
on
go brief
this
some things. Yeah.
or other subjects.
Are you going to play Jeopardy?
No. No, I will not be playing Jeopardy at all.
Pursuit.
But yes, I want to thank all of the panelists for coming in. It's really been fantastic.
Come on up. I can't see it.
What we got?
I'm sure it's fine, but let's just make sure. A little closer. You're all right. I'm here. Have no fear. Okay, thanks. No, it's all right. I just want to make sure there are rules about it, and you seem to be in compliance, so don't worry about it.
Here's a jury gang on camera.
Apologize. People who have to apologize, people broke the rules. Okay.
Like Binger.
And now I will be talking now with the alternates. And they're on their way up, I assume? Yeah. Down wherever they're coming from.
We got a caller. So
caller and tell it, yeah.
Wherever we keep them.
Somewhere in the courthouse.
Storage locker.
Has anyone else found it interesting that Huber's dad has consistently, he's not there now, but has consistently sat behind Kyle?
I did not notice that. I was not aware.
He's the guy who's shaped kind of like Humpty Dumpty or whatever. But he's
Mr. Potato Head.
Yeah, he's bald and he's wide, and so he like has this weird flow. But anyway, even earlier today, he sits over near where the tech person is, and I've just noticed that. I wonder if he's the guy who also flipped off the court at one of the hearings via Zoom, and I was wondering if that's like his intimidation move is. I'm gonna sit behind this murderer who murdered. Like, I don't fault the guy for being mad about his son dying, right? But
sure,
it's a weird move to sit there.
Well, defense table doesn't look too happy.
They were jovial a minute ago.
I know.
They should be happy.
It changed.
The longer this goes, the better off they are, so they should be happy.
Oh, I don't know about that.
I would think faster is better.
Yeah.
Oh, I'm sorry. You said defense. I thought you meant the state. I'm sorry.
Yeah. Oh no, he said defense table, Joe.
Oh.
But they sound a lot alike.
I'm asleep. It's been a long day.
But Binger looks grumpy too. I think they're just tired. They wanted a verdict today.
A long trial, but the jury had so much to go through. I think a verdict today is always a tough sell, and once they asked for all the jury instructions, I think there's a lot of discussion going on.
Right.
But
That is, everybody just got 36. Go ahead. I'm sorry.
No, I was just going to say the prosecution, especially in their rebuttal, was just trying to find their one and to empower their one to be a pain in the ass or to hold out. And they might have done that with somebody that's going to need the rest of the jurors to go line by line with the jury instructions and say, no, this is what it is.
Yeah, I concur.
We'll see what
I think
happens.
that's exactly what's happening.
Yeah.
Binger has one hell of a wardrobe. That's all I'm going to say. It's got a lot of suits.
I mean, there's been a lot. It was always interesting because there were some DAs in our office that dressed very, very well. And I'm like, do you get paid the same that I get paid? Because how? Because I know how much I pay for student loans each month, and I can't pay that for shoes. But
maybe they had an OnlyFans page.
Not back in the day, but I've been going
Binger might
for
though.
years.
I'm not discounting Binger's OnlyFans page. She's like, see where I put my Star Wars pins tomorrow, only on OnlyFans.
Oh no.
On a new shirt, guys. What are you talking about?
Binger does rhyme with something else in there.
Finger.
Well, that's some other things. He has many interesting relationships with many interesting people.
Wasn't that a line from a movie?
Might have
feel
been.
like it was. By the way, someone pointed this out to me via email yesterday. Everyone Takes a Beating Sometimes is actually a movie line from Goodfellas. So Krause may just have impeccable movie taste that is seeped into his closing argument rebuttals.
You should tender Goodfellas as a correct statement of the law.
I was gonna say you got to be careful about quoting mob movies as your legal statements.
Yeah.
Hey, Nick,
especially as the
just as
prosecution.
an aside, I'm pretty stupid about this social media, internet stuff. So I'm love to be back on the show again. I had a great time, but if you want me to, you'll have to send me an email with, idiot level instructions for how to do that.
Well, the one today was sufficient, correct?
Yeah, that worked. Yeah, that was perfect.
Okay, well, I'll send you one for tomorrow. If you want to pop on, you're welcome to. I know it's a long time, so as you are free, you're welcome to pop on.
Yeah, I mean, it worked out great today. There's as you might imagine, there's a lot of media interviews. I'm sure Robert has the same experience, and so it might be in and out. But when I'm not in an interview, then I'm just sitting at the computer like everybody else, waiting for a verdict. So I'm happy to participate.
Perfect.
Yeah,
I will
wanted to
hold
say
you to that contractually.
Good luck.
No, Nick, you made it really easy. To
That's funny.
What were you saying, Richard?
Oh, I was saying essentially that I really appreciated how easy you made it to pop in and out today, because I did have a number of things to hit, but it was super easy to just go in and out.
When Zoom was cooperating, Zoom crashed earlier today in the middle, or not Zoom, StreamYard in the middle of my stream earlier. It was
it killed mine too.
Yep.
Man, we stayed up. Sorry.
No, it's fine. I had no chat and couldn't really maneuver very much. So it was interesting, but it
Yeah, that'd be really frightening.
What's up, Nate? Okay, Judge, let's adjourn this day. Let's get through this. We can do it.
We gotta adjourn the alternates too, though.
Are there any alternates left alive after Jeopardy?
More Jeopardy.
All right, good evening, folks, and
they get
thank
adjourned
you
when
for
they
your
answer 3
patience
Jeopardy
and,
questions.
your participation, and you're still at work, and will be tomorrow. We're retiring for the evening, and we'll return at 9 tomorrow morning. And even though you're under a continuing obligation not to talk with anyone about the case, not a fellow juror, not even all of the fellow jurors, and certainly not with anybody who's, when I say certainly, it kind of downgrades the prior statement. Just don't talk with anybody about the case. Read, watch, or listen to any account of it. We'll start at 9 a.m. Any questions, anybody? Oh, yes. Thank you for saying that. You're welcome to bring something. If you want to bring a laptop or some other device. Obviously, nothing that you would use to access.
We won't let you turn it on, but you can bring it.
It's Mario Party tomorrow, folks. Mario Party tournament.
Switch or a book.
The court sourced its internet from North Korea. Don't worry, they'll be fine.
Whatever device would entertain you. I have stored here.
Uh-oh, do we know if Wisconsin
board
claims
games?
their
Does he have
cell
board games?
He's gonna have trouble.
Trouble.
Several thousand Jeopardy.
Jeopardy. This guy loves Jeopardy.
Get him to
He does love it.
Anybody else?
Yeah,
Any
VHS
questions?
tapes here.
All right. Thank you.
Last time I was called for jury duty, they had Avatar on repeat for 9.5 hours.
Oh gosh.
Which
movie
one?
version?
Last Airbender or
No,
or
Avatar,
movie?
the James
Avatar.
Cameron Blue People.
Oh God, even
9.5
worse.
hours. Notes
That's a
and
lot of
cell phones
Avatar.
taken and everything else. It was great.
I've only watched Avatar once, and I slept through about 2/3 of it. I just couldn't.
If you can
You
imagine,
made a sensible call.
All right.
a movie
Anything else
predicated
this
on
evening?
3D is not looking great on a
Okay.
CRT
Thank you. See you on the morning.
in a jury room.
Correct.
Yeah.
Well, there we go.
There you
That
go.
is the end of it. And thank you, Joe, for saving the stream with that actual functional video. That was very helpful.
His IP is now being targeted. Time to get on a VPN.
Yeah. This stream could be sponsored by NordVPN, but it's not. Nate, man, what's going on? How's Arbery? How's that trial happening?
It's cool. They just rested the prosecution rested its case, and we'll see. I'll say one of the defense attorneys even the judge is like, yo, you gotta calm down. You got Jesse Jackson coming in here now. You got 100 black pastors marching. Like it's starting to get like kind of insane right now. Well, he didn't say that outright, but that's essentially what happened because he had the black pastor comment. It's the one for the third guy. And he's
you got wrecked.
He's a clown.
There you go.
This last guy's a clown.
Okay, so it's just a going towards random YouTube.
Oh no!
Oh, come on. I do want to report that YouTube during this stream, Team YouTube finally responded to me, and they said, "Hey, so sorry it's taken us this in capital long to respond." That may have been in response to my several messages to them that may have been angry. This was a system error on our end that temporarily halted your live stream, but has been fixed. No penalties or restrictions were applied to your channel. Thanks again for your patience.
Better not.
Gray hands. So
system error.
Very, very
YouTube
helpful.
is taking responsibility for it, though. They're not putting it on PBS or anybody else.
Yep. It was a system error that just happened to affect all independent live streams. It was amazing. All in sync. It's cool.
It is hard to imagine an automated error hitting your stream and not an authoritative stream.
Yep.
Per YouTube.
None of the authoritative ones. No, Fox, CBS, ABC.
With the same
Yahoo.
audio and visual.
Yeah.
It does strain
Same audio visual.
credulity.
At least they responded to me well after it mattered. That was nice. I'm very happy.
I'm busy
that they
deciding
did that.
whether I want to risk the strike myself to make a video about it.
But anyways, Nate, you're coming in right at the very end. So is there anything you want to say? I'm about to shut down the show, but I wanted to give you an opportunity.
Oh no, I'm cool. Hello everybody. Lord Self-Defense. I've watched your stuff, man. I really like it. It's cool. My first analysis of the Rittenhouse case, I went to your site and pulled down the jury instructions. So yeah, you do
That's
great
very
work,
kind of you.
Long-time fan. But
I appreciate that.
I've been watching you guys all day, and this seems good. But hopefully they'll get this kid off. I was gambling. I think I lost $100 because I thought they would be out today. I thought it was chicken and grits. After they're going to stay a little for lunch, but that'd be it. But now we're going into day 2 with this. I'm assuming they got a couple of holdouts because the prosecution's last hurrah was just really to their holdout, right? They were literally just speaking to one person and 1 or 2 people in the jury to try to get them to hold out. So it seems to have worked. But I think if there's any justice in this world, this kid's going to be off soon. So, but we'll see.
Well, when you get to be my age, you'll learn not to bet on verdicts.
Yeah.
And not to bet on justice either.
One thing I got to keep telling everybody: stop saying the gun was illegal. Today I'm arguing with these idiots who keep telling he's got an illegal gun. I said, why do you guys keep saying this? They dropped the charge. There's no curfew charge. Stop saying he didn't belong here. Stop saying he had an illegal gun. That's gone. They're not even charging him with that.
Did
anymore.
the media
So please.
update that charge got dismissed? Because I haven't seen those headlines anywhere. Maybe I'm looking in the wrong spot.
I saw one that said it was dropped on a technicality.
Yes, the technicality of
the law
didn't
did not
commit the
apply.
crime.
How bad this is?
Technicality that
Somebody,
the gun didn't match the law
Yeah.
and never
no.
did. We shouldn't have charged it.
it's insane.
That's
Somebody
like saying they
check
don't-
me with PolitiFact. Somebody like,
In fairness.
the PolitiFact. Somebody fact check me with that, and I'm like, that's old. The gun charges aren't there anymore. That's what we got to deal with now.
We have a little meme here. Sorry. Sorry for the offensive language of bingo.
Oh my.
But
That should have had hard. That should have had hard R there. It would have fit with his name better.
And
Binger.
there were media headlines about the technicality in which the judge was yelling at the state for the Fifth Amendment stuff. And
Is a
that's
Fifth
as
Amendment
far from the
violation a
technicality as it comes.
technicality now?
It's
What's
as far
funny
from
is the
technicality as it comes.
It's just a U.S. Constitution. I mean, no big deal.
It's a technicality. when it comes to the
Technicality.
defendant.
What is the institutional media is borrowing from what the right wing did in the 70s, where they referred to all this as kind of technicalities. Defendant got off on a technicality. First Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment. That's what the technicality was. But now the institutional left has borrowed that terminology. The law is now a technicality.
It's always been. Technicality is always either the police screwed up, the prosecution screwed up, or massive rights violation.
But
or
it's-
all three.
And it's almost
But now
like
the massive rights
institutional.
violation is a technicality, and that's where I'm confused.
It's like institutional power doesn't really care about left and right at the end of the day. That's for us peons to argue over, and institutional power is playing a completely different game. I mean,
you have crazy people in the chat, Nick.
I know. I don't know what they're saying, but I do agree. And
we're trying to propose marriage to legal bites.
Be careful.
You have to bring her sandwiches.
I was gonna say, be careful before you agree, Nick.
No, believe me. I've met them.
There was one earlier which was asking if Legal Bites ever paints her toenails on her streams, and
I've gotten a lot of comments on my feet.
And I responded, she doesn't,
Dude,
but I
Legal
do.
Bites have a wiki feet page. Legal Bites, what's your wiki feet page? Can we get you a good wiki feet rating?
Oh God,
Alita, I do want to ask you. I do want to ask Alita a question.
Okay.
Alita's a runner. So today the defense was trying to get in that Arbery was not a runner. So the question the defense attorney asked the coroner was did Arbery have long and dirty toenails?
Nice.
And that was supposed to be, he was asking that.
Not racist
and he
at
said
all.
yes. But he was asking that because he said runners don't generally have long and dirty toenails. They'll cut their toenails because it helps them run. So that was supposedly the it was like,
I'm so glad I switched over to Rittenhouse.
I'm like, what is he asking? Dirty toenails. Why is that question even coming up? But they said it's like a runner's thing, so I'm like, all right, I'll ask the runner.
Okay, if you're ultra marathoning, yeah, I would say that's pretty essential. A marathon, even. Gruesome, but my first marathon, I may or may not have lost a toenail because it was a little too long, and my toe box was just a little bit too narrow. And so my toe was just hitting the top of the toe box a little bit too much, and then it bruised, and eventually that's what happened. But I mean,
it's the weirdest
it
question.
depends on how long they're talking. Like,
I'm
are
just
they
trying
talking
to figure
like?
out what a toe box is.
Sorry,
the front of the shoe.
I was
that's
like,
the
am
front
I
of
going
the
to feel
shoe
better or worse about this story if I get a definition of toe box?
Maybe.
No, it's just the front part of the shoe where your toes are, because if you're pounding the pavement for.
So when you're running, your running shoes need enough space so that your toes can kind of spread out, so that you can actually land properly. So if you don't have enough room in the toe box, then you can run into those kinds of issues. But that's probably more important than making sure that your toenails are perfectly manicured. But I've definitely gone on plenty of runs where my toenails were not. This is more stuff about my feet. The chat
don't worry, the chat's fine.
The chat's
okay with this.
This is on me.
No, but I mean, and then
Come in front of a Nick Rekieta audience and you start referencing your toe box. I don't know what you think is going to happen here.
Someone offered you $10,000 for the toenail.
Expert running testimony.
Someone offered you 10 grand for the toenail. That's all. That's probably where we need to wrap this stream up. All right. To my panel, I'm gonna, if you guys can hang around for just a second, I'd like to say goodbye after the stream. I'm gonna pull us off, play a very short outro to the chat. I'll see you guys tomorrow. Hope you have a good night. Peace. Peace. I should have timed that better.
Your Honor, I'm pretty sure we have a mistrial here, sir.
I'm gonna mistrial my foot up your ass.